Good morning, all. So now it is going to be a marathon session because we are going to deal with such a big enactment of our country, uh, insolvency code and its convergence and divergence, which is the subject we are going to deliberate today. So before taking you to my slides and my other inputs, so I will just give a brief points on few things on the, I think today about 35. Okay, good number of participants. So hope we will have a better interaction. And I will probably allocate last 30 minutes for our discussion so that if you have any doubts, you can put across the entire 2 hours and half, 2.5 hours deliberation. In that, if any doubts you have, you can even in suppose you feel something you want to clarify in between, you can also ask me and we will deliberate, then we'll move on. But anyway, I'm planning to park some 30 minutes for discussion for our deliberation and doubts. Because the topic which we are going to deal is on various uh, uh, what to say subjects, or rather I should say various different aspects, I should say rather. So now, insolvency bankruptcy code, as you all know that after advent of insolvency bankruptcy code, we are all now almost 2017, so 8 years, nearly 8 years, more than 8 years we have traveled, but still 8 years to put into um, uh, very simple. After advent of introduction of NCLT in December 2016, the company's matters were handled. Then after introduction of IBC, then the entire IBC matter came before the NCLT. So this is how the whole system worked and the implementation of IBC worked. As you all know, the IBC introduction also has been done piecemeal, few sections introduced in the beginning, then few sections little later. So there were even schedule itself is there. There are different kind of schedule also there. So of course, now we are not in a basic level. Now I know all friends attending today's session must have been must be a insolvency professional and also must be handling various assignments. So I'm not going to take you to basics. Okay, the idea here to understand the nuances of the practice and provisions of the law, rather going for the basics. Basics anyway, we all by now we must be thorough. Or we would have handled also many assignments and got and we had become familiar with the basic provisions also. Okay. Now, Insolvency Code and Companies Act. So, what is the basic uh, divergence and convergence? So, what all along the convergence and divergence that we need to see. So, I'm not going to too much put a question to you because anyway you will be in the hearing mode for some time. After some time, when it hits your personal case or personal idea, then you will open up. That I know. So I'm not going to take any of one of your inputs now. So during my deliberation, something hits you, you can open your mouth. Okay. So now, see the basic idea of dealing with this chapter or this particular topic, subject, the interplay between IBC and Companies Act, both are major enactments. And rather, I should say, Insolvency Code is much bigger enactment. And it's a code altogether. It's not even an act. You all know. Even it has got a 238 has got a non-substantive provision wherein it overrides, it shadow the other provisions of the enactment in the country. So that level, this code is given importance in our country. In fact, I always used to highlight this particular point whenever I discuss on the insolvency code. This is the such a bigger subject or law of our country. Next to our civil procedure code and next to our criminal procedure code. That's the reason this is codified as a code by the government. Why it is not act? Have you any one of you sitting here would have thought about this thing? Why this is not as an act? Why government has not brought it as an act? Insolvency Bankruptcy Act 2016. Why it is brought as a introduced as a code? There must be some difference between the code and act. No, otherwise they should not have been introduced and enacted as a code. So that means then it has got some purpose. What is the purpose only we need to understand. So the purpose here is that Companies Act 2013, and for of course I've got a slide about 300 and odd pages of slides. If I run the slides itself, my 2.5 hours will get over. Okay, my idea is not to simply run my slide and make you to read my slide and somehow push the time. No, it's not my idea. My idea to deliberate and talk about the issues, what we are facing and what is the solution for those issues. Or if suppose there is no provision, then what it could be the solution for that in the absence of those provisions. So that we can escalate the same to the higher authorities and departments and lawmakers, so that they will also will see to that some solution is given in the code and law, both in the act and in fact I keep telling from the time insolvency bankruptcy code, because I can openly deliberate this point, because it's not today I'm talking this topic. Right from insolvency code has come. Since I'm in the practice of company secretary, so we keep meeting regional directors and ministry officials, all that, even not even an assignment purpose, even to clarify their doubt itself, we used to I used to be invited by them, by the department, to clarify their doubts and to discuss some points and all. Even when I write books and when I inaugurate books, the what are the points I get, I share those points. I'd say gray areas, which the ministry has missed out, which the ministry has pondered the attention on that particular, whether it's a Companies Act, LLP or INB code or whatever it is. I always escalated the gray points, the missed out points by the ministry to the ministry itself. Whenever I conclude my writing of books after release of my books, I always prepare a list and send to the ministry and say that these are the gray areas where supposed to be rectified or solution should be brought in. And it happened also. In fact, a few times my suggestion self took up by the ministry, and they introduced the certain provisions also, they notified immediately after they understand the nuances of the provisions of INB code. So today it's not that just for the sake of deliberation I am before you. Today I'm sitting before you, really I feel it that it should happen and there should be a solution for it. It's not that simply we are discussing some topic and we run away. It's not like that, where we are not a college student, where simply we are attending some class and looking for the next class. No. And then looking for the end of the day, so that our day is getting over. No. We are a practicing professional. Everyone will encounter, I know every side, different kind of problems, whether it's authority, whether it's a court, who it may be, promoters, and everywhere. Every nook and corner and every side will be targeted as a RP, IRP, or liquidator. So unless we are familiar with the provisions, it is highly difficult to deal with everyone. Because everyone, I'm saying everyone, even though they know the provisions, they will not give solution to us. They will try to see that how we can be taken for a ride, or how to get things done through us. We are forgetting, as if they have forgotten, they have forgotten the provisions, as if they are not aware of the provisions, though they are aware of the provisions. In my practice, I observe this way. Many people are behaving outside world as if they are not aware of the provision, but they must be knowing the provision. And they will be asking as solutions or remedies, or asking us to do certain things which may not be permitted to do. I'm saying the department. Even filing of returns, department are insisting. I'll explain you the whole legal provisions, what today it is there in the Companies Act, even in Income Tax Act, even in Companies Act. I'll show you all the points. What are the things? But though it is not mandatory on our part, but department keep insisting and many stakeholders keep insisting us to do. Anyway, we have to do what we are legally bound to do. No doubt at all, and we are fully governed by the provisions of the Insolvency Code and with the directions of Honorable Executive Authority. No doubt on that. With that premise, we will move on to the topic of the interplay between IBC and the Companies Act. Okay. So as I was referring in the beginning itself, Insolvency Bankruptcy Code is not a simple law. It is a code. Why it is a code? Because the government want to address all financial failures of the country. Why there are laws are there to address the financial failure? Why we need such a big code called Insolvency Bankruptcy Code? Because the financial failures is not addressed by the present prevailing laws of the country. What are the prevailing laws then? Prevailing laws that point of time when the INB code was introduced, Presidential Insolvency Act, Provincial Insolvency Act, then what else? Then BAFR and certain SICA provisions and certain provisions of the Companies Act with regard to winding up. These are the provisions were already inbuilt the time when the before replacement of those provisions by introduction of the INB code. That means before introduction of the INB code, there were provisions, but that was not effective. See, that's what the government felt, that it is not effective. We should have a consolidated law where it provides one piece of legislation that provides solution to every financial failures of the in our country. So this is the main idea of introduction of this insolvency code in our country. Companies Act 2013 that you all know. I don't know what are the background of 2013. Many of you, I presume many of you maybe know it, but for the benefit of those who are not aware of it, or those who have did not have opportunity to know it, I will share this also. Why the purpose of insolvency bankruptcy code? Which way I explained to you. What is the purpose of Companies Act 2013? Because 1956 Act, such a 60 years old act, why it has to be replaced with so many provisions of 470 sections of the 19 in fact 656 sections of the 1956 Act, why it has to be replaced with the 470 sections of the Companies Act 2013? There is a reason behind it. That only I wanted to share. In fact, when the bill was introduced in the beginning, I know many of you must have heard, but still, the original thought process started 1997, introduction of 2013 Act. You see how much time it took, almost how much time it took. Okay, because why that much time is taken? But see, the idea here is, in fact, rather I should say, not even that. I have to rather say, the whole discussion started in 2008. Actually speaking, in 2008, the whole discussion has started. Yes, 2008. Then it almost some five, six times the bill got presented in the parliament, then got. But originally it kick-started that the mood discussion of new act, that the country required a new act in replacement of 1956 Act, it triggered in 1997. That only I am saying. 1997 to 2013, 15 years it took for our government to bring such an enactment. See, that is the reason you see how many amendments would have got introduced before that, because they could not able to bring the enactment, because there were a lot of inbuilt issues have come to introduce the act. So they ensured finally, okay, 2011 bill, 2013 bill, 2012 bill, then 13 bill. Then 13 bill became 13 Act. So why I'm giving this history of it? When we know the history, only we can understand the purpose of the law. why the law and what went into the mind of the lawmakers, legislature to bring this law. Then only we can understand the intention of the law. So originally when the law was brought in 2013 Act, I'm saying, why originally when they were intending to bring the law 2013, they wanted to simplify the law of 1956. But what has happened while introduction of 2013 Act was totally different. But it is totally turned around the entire focus of the government. Why? Because of few scams. You all must be heard all these scams, everything in the open book and everything in the open page. So it's not something I'm sharing, is something which I alone know. The time when the Companies Act was supposed to be introduced by the government in 2011-12, there was a big scam came up in our country, some 3-4 scams. You must be knowing this Satyam, Sahara, Sharda, all these scams were lined up. So government completely thought, okay, this simplification of Companies Act is no longer help us. They fully kept the bill away, 2012 bill, and prepared a new bill 2013 with a lot of provisions. I'll show you those provisions also. Now, why today we are practicing Companies Act with so many of stringent provisions like 447. There are so many sections I can, 448 and 449, all these sections and many other sections I can put in Companies Act. Why it became so stringent? Because of to see that, make sure that the scams and whatever the wrongdoings or misdeeds done by the corporates are plugged in. So this is the idea of bringing Companies Act 2013. Okay. Now we have visited the purpose of the IBC code. It is to address the financial failures of our country. The purpose of the Companies Act 2013, it is to address the companies are not doing any misdeeds, or not doing any defraud of transactions. So to plug that, we need a strict law in our country. That's the reason where government has brought in Companies Act 2013. But even you see, Companies Act 2013, but INB code is a code. Why it has to be a code? Because by bringing Companies Act 2013, no other acts are getting amended. No other acts are getting amended. But by bringing an Insolvency Code 2016, how many acts are amended? How many schedules are there? 11 schedules are there. Almost some 34 amendments is introduced without amending the respective law. Means without following the parliamentary process of, without following the legislative process of amending some 11 enactments. By introducing insolvency bankruptcy, go to all 11 enactments, stand amended, stood amended. Today, we are reading, after the introduction of the Insolvency Bankruptcy Code, we are reading all respective 11 enactments with the new provisions, without a separate amendment, without any separate legislative process. That is the power of the code. The power of the code is that it is a guiding light, or torch. We say it's a torchbearer of entire financial failures. Okay, and the guiding force of entire act governing the financial failures. Even there is a law called surfacing. You all must be knowing, but still the law was not effective, and that law only enacted, you all know, that to give more of remedy to the financial institutions, not to the corporate, not to the stakeholders of corporate. So that is the reason they want to bring a revival process in a speedy manner, and they brought the law called Insolvency Bankruptcy Code 2016. And to make sure this code is working proper or implemented proper, they introduced Schedule 11 in the code. If you can see, you can all see that section 450. There are 10 sections are there. I'll show you all those provisions in subsequent slides. There's a separate sections, 11 sections are introduced, are parked, are allocated, just to make sure 11 enactments are amended parallelly by introduction of the Insolvency Bankruptcy Code. This is the idea of introducing the Insolvency Bankruptcy Code as a code, not as an act. 2016 is as a code 2016. So this is the very important thing which we need to understand. Okay. Now, is that any synchronization is taken place between the INB code and Companies Act? Is there any synchronization? Or is that any, that's what the convergence, what we are talking. Any convergence is there? Or what are the provisions which really converge? Or what are the provisions? There's a divergence is there, and it is not going together with the provisions of Companies Act. Okay. If provisions of INB code, see the idea of this particular session itself, that we need to understand where the provisions of Companies Act and where the provisions of Insolvency Code goes together, where it goes like this. Can we see that? Where it goes together, where it goes this way. That's called divergence, and this called convergence. Okay, that's how the institute has correctly, languaged the topic. Okay, INB code and the Companies Act, the divergence and convergence. Okay, let's see where are the convergence has happened place in the provisions of the Insolvency Code, where all the divergences took place in the provisions of Insolvency Code 2016 and provisions of Companies Act. Okay, now I will take you to the sections and PPT and share my screen also. Okay. Till now, if you have any doubt, you can ask me. Otherwise, I'll move forward with going with my own inputs, my PPTs. So I'll share my screen. I'll take you through the Companies Act 2013 provisions, where the provisions of Insolvency Bankruptcy Code really has got a convergence. I've got mixed up, or what to say, that gel, where the provisions of Companies Act really has got gel with the Insolvency Bankruptcy Code, where the provisions of Insolvency Code has gel with the provisions of the Companies Act 2013. I'll take you through all the provisions and see. Let's try to find out the difference. Okay, and find out the difference and find out the similarities, and both we'll see now. I'll share the screen now. Okay, so now okay. Wait. I'll take my folder. I'll put it in same folder. Okay, so that it will be easy for us to see. Okay. Okay. Now coming to Companies Act. See, this only I was referring. I've got slide even to make, in fact, to deliberate better every point of Companies Act. I thought I wanted to take you through this PPT, entire PPT, but still, how many pages are there? 230, I'm sorry, 300 and odd pages are there. I'll show you. See? Some 300 odd pages are there. Okay. What I will do, my idea is not to, as I was referring the beginning of session itself, my idea is not to make you to understand a Companies Act or make you to understand the Insolvency Code, because that's all these basic things you must have by now be familiar with all these basic things. Here, our focus today should be that where the intercases where there's a similarity, where there's a convergence, the divergence between the insolvency code and uh, uh, means Companies Act 2013. I'll take you through the PPT because I've got some 4-5 PPTs to show today. Okay, so I've got number of PPTs. Topic wise, I've got a PPT to present today. But before that, I wanted to take you through the differences between the, I was referring the provisions of respective Companies Act and respective insolvency code. I wanted to take those provisions so that it will be easy for you to relate. When I explain to you, it will be easy for you to relate. So let me see that one. Right. Okay. See now to understand where there is a convergence divergence. First, we need to see where and all the provisions of insolvency code is referred in the Companies Act 2013. Is it not important? Is it not important? Where the provisions of INB code is referred in the Companies Act 2013. So that means those provisions of insolvency code has been brought into the Companies Act 2013 as already. So we can try to deliberate the provision which is there. Then we will see that what are the provisions that we may require in future for better implementation or better practice our profession, insolvency profession. Okay, what are the amendments or what are the changes that may require? That we will conclude, we will summarize at the end of the session so that that same can be taken up by our institute and also the Ministry of Corporate Affairs so that they may look into that. So before moving forward, I want you to show one important thing. See, wait, basic thing only, but still very important thing. Okay, let's move on to understand on provision relating to articles of association. Okay, see, articles of association. See, act to override articles, a memorandum and articles. Here it says act to override. Okay. So here it says, okay, provisions of this act shall, notwithstanding to contrary contained in the memorandum and article of the company or any agreement or any resolution. So here it's not saying any other act, it only says respective thing. Okay, whether same be registered or executed. Okay, so any provision contained memorandum article to the extent which is repugnant to the provisions of this act, repugnant to the provisions of this act, become or be void as the case may be. Okay, so any provision contained in the memorandum, and I'm talking this particular point. Okay, even I can highlight this point. I'll just leave it to you to think, nothing else. Then we will move on. That's fine. Okay. Any provision contained in the memorandum, articles, agreement, resolution shall, to the extent to which it is repugnant to the provision of this act, become or be void as the case may be. So suppose the provision contained in the memorandum and article, okay, an agreement, a resolution of a company which is under CERP, of a company under liquidation, if the provision in the insolvency bankruptcy code is repugnant to the provisions of this, I'm saying the provisions of memorandum articles of association, if it is repugnant to the provisions of the insolvency bankruptcy code, will it deemed as void or not? I'm just taking you through few points which for you food for thought. Okay. Here, another important thing. See, this also, it is important to understand. In case of any company which is registered, okay. So in so far as the registered articles of such company do not exclude modified regulation contain the model. You know, table F is their model. Those regulations so far as they are the same manner to the extent if they contain duly registered. Otherwise, table F they are saying. Okay, table F also I was seeing. There is no provision, there is no. So that means the act and read to the table F, okay, does not talks about anything on if the memorandum article has got repugnant provision to, means repugnant to the provisions of the insolvency bankruptcy code. What is the fate of the memorandum article? Will it bind? Means whether the directors are obligated to follow or not. Will it bind the company or not? Because it only says which is repugnant to the provisions of this act become or be void. If it is not, if it is repugnant to any other act, provisions of any other act, it is not void. So that has to be followed. Okay. I'll take you to sections 166 in these aspects. Okay, 166, which give duties to the directors. What duties it gives to the directors? The subject to the provisions of this act, a director of a company shall act in accordance with the articles of the company. A director of a company shall act in accordance with articles of the company. We are on the same page? Okay. Here, the provisions of the act says the duties of director is that the director of the company shall act in accordance with the articles of the company. Okay. It is a duty of given to the director. Okay. Now, what happened once company comes into CERP? Okay. I will take you through now to code. We will see the code. Where is the divergence? How to deal with this divergence? Okay. Now let's go through the section wherein it says when company comes into CRP, what happens? Okay. What happens? In fact, I'm going to deliberate much detail about this particular provisions to 17, 18, 18, 20, 21. I'm going to deliberate in detail. But now, just for particular aspects of complying the provisions or adhering to the provisions of article memorandum, I'm talking now. I'm not talking other things right as of now, because I'm going to deal one by one in going forward, one by one. But now I'm dealing with the specific two provisions of articles and memorandum and the obligation given to follow the provisions of article and memorandum. Okay. So because that's the basic crux. Because here the code mandate the IRP to follow something. Okay, it says the IRP has to follow something. Okay, or RP has to follow what is provided in the code. Okay, now it says the powers of the board of directors shall stand suspended and be exercised by IRP. Same provision is extended to RP also. Okay. So now power of the board of directors. Okay. I'll highlight this. Okay. Powers of the board of directors shall stand suspended and be exercised by IR. There, I was showing here the duties given here to director is that he shall act in accordance with the articles of the company. Whether the same duty is given to IRP, that he has to act as per the article. No doubt there is a provision inbuilt where it says one provision has been introduced. You all know this provision has been introduced much later after introduction of the code. When it got introduced, by an amendment in June 6th June 2018, it has been introduced after a year. 1.5 years later, it indeed got introduced. Okay. What got introduced? The IRP responsible for complying the requirement under any law for time being enforced on. So it is responsible for complying with the requirement under any law. Whether that any law includes, we have to presume that this includes the complying the requirement of article and memorandum also. Fortunately, this provision has been included much later. In fact, we were deliberating that time itself many forum that where is the compliance responsibility is given. How I can sign a form unless there's a responsibility is given to us. The responsibility is given in the beginning. I'm saying at the time of introduction of the INB code, what the duties is given, what is the responsibility is given. It is only the responsibility is given to manage the affairs, and power of the directors got suspended, and the power is given to the IRP to exercise the power. But later on, the government realized, the regulatory authority, they realized that there should be a mandate. Then only the IRP or RP can really, they'll have authority to follow the provisions or to sign or to implement certain, to do certain things in order to comply the provisions of that. Unless there is authority, it cannot be done. So now, unless this provision means accept the benefit of doubt that just because of the class E of subsection 2 of section 70, okay, since this gives little extended arm to the IRP, there is no other extended arm I have to given to IRP to follow the requirement of article and memorandum which the duty is given to the director. Here, very importantly, why I have to bring this particular thing. Here, the duty powers of the directors alone suspended. Powers of director alone suspended. Rather, I have to say here, see, please understand this powers alone suspended, not duty suspended. Of course, this deliberation is done by many people, but still there is no clarity emerged. But still, we every as IRP and RP as liquidator, we are rendering our duty as if it is inbuilt. Okay, we presume that we are obligated to do, and we are rendering the duties of directors, and even not only the powers of director, even duties of director also IRP. But is it obligated under the law only is my question. We are rendering on our own as a matter of prudent, and we want to follow the law because the court gives a obligation as IRP, RP to liquidator to comply the law. We are following it. But Act is enabling. Is the Companies Act 2013 enables it? Is that Act empowers it? That only is the question now before us. Whether the Companies Act empowers it. Empowers IRP or RP to render the duties of director. Duties of director. That's more important. See here, the duties is separately given. What are the duties? You see here, the duties. They have to comply the articles and they shall act in accordance with the articles. What are duties? The director of the company shall act in good faith in order to promote the object of the company for the benefit. So this duty cannot be given to IRP or RP because the IRP RP also given an obligation to keep the corporate data as a going concern. He is also given a card because it's a revival process only. If he is given a 330 days, it's given a window for revival process. Then he has got the same duty just like a director has got to promote the object of the company for the benefits of the members. The director of the company shall exercise his duties with due and reasonable care, skill, diligence. Of course, we have our own code as insolvency professional, but not as part of the Companies Act, I'm saying. Okay, we have our own code as an insolvency professional, what we are supposed to do, what we are not supposed to do. Okay, and to act in good faith, all that is there in our code of conduct. Okay, in INB code I'm saying. Okay, a director of a company shall exercise his duties with due and reasonable care, skill, diligence, and shall exercise independent judgment. The same thing is that in our code of conduct, as we have to see that we are executing with a reasonable care as insolvency professional, skill, diligence. But please note, there is no convergence with respect to the duties of a director with the duties of IRP. What the provisions under the code of conduct of the INB code is a code prescribed to be followed by insolvency professional. Okay, but it is not direct connotation with the director without his IRP or RP. That is my deliberation goes in that aspect. There is no direct connotation. The director without his IRP. It is the code of conduct which provides different obligation to insolvency professional to follow. Here, the Companies Act gives a specific obligation to director, duty to director to comply it and to follow it. A director of a company shall not involve in a situation in which he may have to have a direct, indirect interest that conflicts or possibly may conflict with the interest of the company. Then the insolvency code, there is a provision in the regulation where when we are appointing a professional that we should not have any, only in case of appointment of professionals only, not otherwise. Here you see, shall not involve in a situation in which he may have a direct, indirect. It is wider in term when it comes to a director and very restrictive in term when it comes to IRP, RP and liquidator with respect to dealing with the conflicts and saying interest. Indirect interest that conflicts the role. Okay. A director of the company shall not achieve or attempt to achieve any undue gain or advantage either himself or related. The same provision, number of provisions are there. The code also there. And of course, the code, as I was referring, code of conduct says many things, not the code. I'm saying the code does not say in replacement of the duties of director. No. The code says as an insolvency professional what you're supposed to abide or what you're supposed to follow and obey and adhere. Okay. Not with respect to the director of the company. There is no connection between them, but those things can be applied and can be followed by insolvency professional. That we are doing it also as insolvency professional. Okay. A director of a company shall not assign his office on any assignment so made shall be void. So this is the reason I remember regulatory authority also came up. They came up with a circular that the responsibility duties of insolvency professional should not be assigned. You can take help of professional, but you don't assign your duty responsibility because here director cannot do. If a director of a company contravenes the provision of the section, such a director will be punished. There are different kind of we'll show. I'll show you at the end of the after section 70. We have a lot of provision under the insolvency bankruptcy code. All talks about all this penalty and punishment. Here, why I have to very deliberate, detailed way I have to deliberate this particular point. Here, if you see in code, I'm saying. Here in code, it says powers of the director is suspended, okay, and be excised. As I was referring under section 166, duties of director, I even read out all the duties also. But that duties not exactly copy pasted to IRP, RP to follow. It's not copy pasted, okay? Because we are here the code suspend the directors powers of the director. The code suspends and gives in the hands of the IRP. Duties, whether it is suspending, that government only has to answer. Of course, the duties are taken as inbuilt by the IRP, as I was referring, as insolvency professional, we have our own code and we are even additionally taking care of the duties also, no doubt. But whether law provides for, no, law does not provide for. Law only provides that you have as IRP or RP to handle the powers of the board of directors. Duties of board of directors, 166. Can we say that if any violations under the provisions of Companies Act during the 330 days, why I have to highlight this particular point in a detailed way? It has got legal impact. Okay. During the 330 days, when the IRP, RP managing the show, entire show of CAR, running the business, managing the affairs, everything they are doing, okay, there is a non-compliance. Who is responsible? I'm not talking about the responsibility what is given under the code. I'm not talking about. This is a responsibility given. The responsibility given under the code. Otherwise, the RP, ARP is responsible under the code 1956, 2016 of INP code. This is a responsibility given under the code for IRP and RP. Not under the Companies Act. Not under the Companies Act. For sure, not under the Companies Act. Under Section 17 of INP code, it gives certain responsibility to manage the affairs by IRP. In that, it says you don't simply manage the affairs. You please take note that it's your responsibility also is there to comply all requirements of any law for time being in force of the corporate actor on behalf of the corporate actor. Any law, not that only Companies Act, Income Tax Act, or any particular act. Any law with respect to the. So the responsibility to comply is given. Now, question only now comes, in case of violation, who is responsible? During the 330 days, in case of violation, who is responsible? Because it's a running company. Is that any protection given? Is that any protection given during CARP 330 days time? Liquidator, I'll take you through in detail liquidator. That's totally different provisions and different, the law see in a different eye, the liquidator. Though all everybody outside world, they are trying to confuse and try to bring everything together for their own hidden purpose. Okay, I'm saying the world, outside world. For their hidden motive, they bring everything together. If they want to achieve something, they will separate and see. No, this is only for IRP, RP. This is not for liquidator. This is not for liquidation. This is only for CARP, RP. When they have some motive to achieve, no, it is nothing that all the process same only. He only responsible for everything. Blah, 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 blah. So they completely talk all blah, blah to the court. Okay. When they want, they will combine everything, the responsibility of the person. When they don't want, they will separate it and see it. Okay. Now, coming to the question, if a director contravenes the provisions of this section, such a director shall be punishable with the fine which shall not be less than 1 lakh rupees, which may extend 5 lakh rupees. Whether, since the powers are suspended under the INB code and responsibility is given under the INB code to comply the provision, whether the registrar of companies and regional director, MCA, has power to issue show cause notice to IRP, RP that you are violated the provisions of the Act because the powers of the director is suspended. Can we take a stand that no, only powers are suspended, duties are not suspended, duties with the board of directors? Can you show any single legal notice is served? Can you show one single show cause notice served by the department? If anyone can show you, please show me. We will change the topic and move on to next topic. During CARP, while managing the affairs by IRP and RP, okay, in case of any violations, the notice is served to the directors of the CD. Can you show me any show cause notice? Because the duty is not given to IRP, RP. According to the code, the powers of the director is suspended. Duties is not suspended. According to the code, I'm saying. It's not my view, I'm saying. According to the code sound, the powers of the director suspended and exercised by the IRP. The language of the code does not say powers and duties of the directors suspended and shall be exercised by the IRP. But it gives separate duties to IRP. no doubt. We are not denying that. There's a separate duties is given to IRP. Whatever I'm talking to IRP, same thing is to RP only. You need not to confuse at all. Whatever I'm talking about IRP, it's RP also. IRP and RP also. Both. Same legal position. Okay. Not much difference between the IRP and RP in the code with respect to all these aspects. So the code gives the duties of IRP, that IRP shall perform the duties. All collecting all details, receiving, collating, all that, contributing, committee of data, monitor assets, all that. These are the duties completely given to IRP. Wide duties. Can we say, by reading this, the lawmakers are very clear. The lawmakers are very clear. Okay, the legislature is very clear. What duty should be given to IRP? The IRP can be given duties only collect the information of assets, okay, for determining the financial position of CD relating to business operation, financial list of assets. Okay. The duties can be given to IRP to receive, collect claims. Duties can be given to IRP to constitute COC. Same way to monitor assets of the CD, the duties can be given. Manage its affairs until RP is appointed, all this is there. File information collected, okay. Take control and custody of any assets over which CD has ownership. This duty also is given. To perform such a duty as may be specified by the board. To my knowledge, board has not specified any other duty apart from that. There are many provisions are there which as a RP has to follow and IRP RP has to follow. Regulatory authority has came out with a lot of provisions, okay, but not specifically in addition to the duties prescribed under section 18 that the following duties are not additionally brought in by regulatory authority. Okay, so that means these are the duties is given. Can we take a stand or can we say that the code specifically gives the duties of section 18 code specifically gives the duties to IRP A, B, C, D, E, F, G. Section 166 duty is not applicable to me. This is not applicable to me. Can we take a stand? Because Companies Act 166 gives certain duties. It is not that just duties, please understand. It is not just duties. There's a replication on that under subsection 7. Problem is because of this replication only. If it is only a duty is given and it become part of their as part of their fiduciary responsibility and duties, these duties are given, it's fine. Because that has got certain fiduciary duty. Additionally, they are given some duties attached to that. It's fine. But it's not so. Here, there's a provision where it triggers prosecution. There's a provision which triggers prosecution when you don't follow their duties. See, suppose the question which I put already to you all, suppose the ROC, Regional Director of the MCA, conduct inspection. During this quoted 330 days time, because the 330 day time is the going concern. Okay, 330 days they do inspection because RP, IRP, they are given obligation to manage the affairs of the company as a going concern. It is a company. Only thing the director's powers are suspended. You are sitting in the chairs of directors and exercise the powers of directors. Right. When 206 inspection is commenced or started, kick-started, initiated, 206 inspection under Companies Act. Okay, 206, then 206, then it percolates into 207, then 209, then 210, 211, then it percolates into investigation. Assuming, I'm telling the scenario. In fact, all this scenario also has come before the court, but this is not answered. The question what we are deliberating now is not answered. All the scenario in different cases has come. Even one of the Pooja Bagri case also, I remember I've seen. Court has given some verdict on that, but on a different context, not on this context. So here, within this quoted 330 days time, which is given obligation, which is given as a deadline or a timeline for a IRP, RP and IRP, IRP and RP, the 330 days that they have to make sure the CD should be managed and should be managed as a going concern, and everything has to be done to the CD as just like a going concern. Okay. In that 330 days time, an inspection is ordered that percolates into investigation. 209, 210, 211 investigation. Okay. Then the ROC pulls out, or the inspecting officer pull out. The officers pull out about 20 offences committed or 20 violations committed by the company during inspection, or even balance sheet or whatever it taking. Even technical scrutiny itself, they can conduct, they can issue show cause notice and seek information. Then they can start conducting inspection and investigation later on. Even with the balance scrutiny itself, it can start. Need not to do even 206 inspection at all. Okay. So in that case, suppose some 20 violations unearthed by the inspecting officer. Out of the 20 violations, 10 pertains pre-CARP, 10 pertains pre-CARP, 10 pertains during CARP violations. Okay. Now let's discuss or let's deliberate. 10 violation that is unearthed by department during the inspection of records or investigation, whatever it is. During CARP only, I'm saying, during CARP 330 days time. That 10 violations or 10 offences whatever committed are in the opinion of officer that offence is committed, who is responsible? Whether RP is responsible is to go for compounding of offence under 441. Whether is that RP is responsible to compound the offence under 441. Suppose if the offence is non-compoundable, then RP has to go behind the bar. Pre-CARP, anyway, there is a clarity that director has rendered, they has given a duty or responsibility to comply the law because they only were running the show, so they are responsible. No, there's no question on that. There's no doubt on that. Directors can be taken for task by the department. That here the challenges is only during CARP. The offence is committed. 206. In fact, I don't know whether I have a slide for 206 because I have last slide. The 206 I have, whether I don't know. Wait. Yeah, I think I included that also, correct. I included that also in the slide. So that may be useful to everyone. I included. No, I wanted to show you what is the for the purpose of understanding the seriousness only, I wanted to show what it is. What and all can happen if 206 inspection is commenced and the investigation is commenced. What and all will happen? So what is the fate of RPIRP is the question. See, I'm also insolvency professional. I also handle the cases. Then who will take responsibility of it? Few things due to procedural difficulties, the RPIRP may not be in a position, or due to non-cooperation also he may not be in a position to comply the process due to non-cooperation from the management. Yes, I thought I included 206. Serious fraud I included. Okay. 206 I got a separate slide. Okay. Anyway, I just additionally I thought I can show you that. I directly, tell me.
Small question.
Yeah.
If CRP is commenced,
Mm.
IRP or RP is taken into control, is
Mm.
this not 6 is barred? Maybe.
No, can you come again, please?
No. If CRP is commenced and IRP or RP is appointed,
Mm.
the proceedings of 206 is barred, I think.
Proceedings of 206 barred.
Maybe.
But many companies, even during liquidation, they are serving show cause notice department. Even they are conducting also. I have seen many cases. They are conducting inspection even during liquidation. I am quite against to that. At least ERP is okay. But during liquidation itself, they are conducting inspection. How the liquidator can supply the details for inspection? He can't supply the details because he has not given that obligations at all, which I will explain you in detail. What is the obligation a liquidator has got? But at least in CRP, see, this is the 206 which anyway, we'll discuss that. I'll take you to that code. Since the point raised, valid point, we will go through the code, know what it is there in the code.
Surely.
See, wait. Yeah. Again, same thing is coming. No, I'll go like this. PDF. Okay. Now, please come to, since the queries come, now let's understand. Okay. All this we are aware. Section 19 personal, they have to extend the cooperation. All it is there, but they are extending cooperation or not is $1 million question. You must be knowing. You all must be knowing. Everyone would have encountered, but in few cases, fortunately, you would have got cooperation also. Okay. If you are getting cooperation means then you are more fortunate. Okay. Otherwise, there's nothing to regret. Because we know it is expected only they will not cooperate. When their company is taken away from them, who will cooperate? They will have that tendency not to cooperate. Okay. The management of affairs of the company as a going concern. Okay. This only I was referring. So management of operations of corporate debtor as a going concern. So the IRP shall make every endeavor to protect, preserve value of the property and manage the operations of the concern. So that means he has to make sure everything is doing. You show me where is the moratorium is given. Problem is this only. Here, the moratorium, if you go and see the moratorium.
Okay.
Yeah, that only I'm showing. Okay. The institution of suit, consideration of pending suit, or proceeding against corporate debtor. So, institution of suit, or continuation of pending suit, or
proceedings.
Yes. So that means the proceeding should not have initiated. Correct?
Yes, sir.
That's what you are trying to say.
Correct. Any proceedings means do not consider proceeding.
They are doing inspection. Fortunately, unfortunately, our good friends, IRP friends and liquidator friends are completely supplying detail, completely ensuring they are conducting inspection without knowing all these intricacies. Or they may be knowing the intricacies, but without understanding seriousness of all this.
Correct.
They are supplying. Unfortunately, our friends are supplying. That's my concern. It's not that, in fact, I myself got that inspection notice. It's not I am simply reading the provision and I'm telling you. Don't think anything I'm sharing here, just reading the law, what is here, what I'm sharing is out of my own experience. And wherever required, I'm referring the provisions of the law because I don't want to tell like a story. Okay, it's not a television where story and flash and give just like a story. In Supreme Court case itself, they are giving like a story only. I'm seeing the televisions. Okay, their story today's story. Supreme Court has ACC has come this. My God, they started interpreting a story. Even judgments of Supreme Court itself. So we can't do that way.
Why I asked that question, sir? Actually, in upcoming 2025 amendment also, The moratorium is extending to liquidation part also.
Sir, moratorium is already there in liquidation, sir. No. See, actually speaking, see, I'll show you the difference. Here's moratorium, see, na? Institution continuation, correct? The language, please remember this language. Okay, I'll take you to 33.5. Just see the difference of the language. Moratorium already is there. So first of all, let them follow the provision which is there in the code and act. If that itself is a big help they are doing to insolvency professional. If somebody follow the law, I'm saying the outside world, I'm saying.
Correct, sir, correct.
Nobody is following the law. They don't want to understand the law at all. See?
Under
Now,
clause 5, subject to section 52, when liquidator or order has been passed, no suit or other legal procedure. Exactly, it implicates the moratorium only.
it is there already. We are fighting that there's a provision last 5 years. I am fighting this. Okay. In fact, I won one income tax case itself a big demand, big amount demand. I won also against them. Okay. That you can't do anything. There's a moratorium is there.
Perfectly.
Oh, it's not that there is no moratorium. Problem here, why I showed this particularly, when inspection and investigation is conducted, what will happen? Okay, leave at all inspection investigation. Okay, sir. Fine. I'll now right now park your question.
No.
I'll come now in a different aspects.
Sir.
No inspection, sir. When I commence inspection only, you are telling no. That okay, no inspection. Okay. I am just taking your balance sheet. What is filed? What is filed? I am taking. Or leave at all balance sheet. I'm just taking your form that you have filed during CAR. Just taking some form. Okay. I'm finding something as officer sitting in the MC. I'm finding that some violation is there. There's no proper document for that. According to me, it is a violation. You prove in the court of law, it is not violation. I'm issuing a show cause notice to you. I'm issuing show cause notice to you. Whether issuing of this show cause notice itself, will you say commencement of proceeding?
No, show cause notice won't consider that.
So it's not that inspection investigation that they have to issue show cause notice. It is sufficient if officer. That's why I wanted to show you before that you started the thing. In fact that's the reason I started to show what is the impact of 206. See, 206 inspection. This only I wanted to show you. Inspection, inquiry, investigation on a scrutiny of document filed by company. You please here you see it is not about inspection at all. Just scrutiny. Just by doing scrutiny filed by a company. Here filed by a company includes company CD under CARP. It is not excluded here.
It means any complaint made before the SFI also falls under this, sir.
That's why I'm saying. See, it starts from 206. Okay. Just see, I'll show you quickly. I'll show you so that you will have a little idea. See, on scrutiny of document, a written notice is sent, an opinion is formed, and written notice is sent. All it is done wherever I'm showing you as a company. I am deeming in my mind that company is that also includes the CD in CR because it cannot be excluded. I'm just saying because even today the argument is going outside the department, even still arguing. No, I can do inspection. It is a running company only. No, the running company. Then something goes wrong. Then how we will come to know as a department. See, liquidation is fine. Liquidation is not operations at all because the liquidator is given a task of managing the affairs. I'll show you that language also there.
The demolishing of all the assets.
I'll show you that language also. Go on next slide. Liquidator is given only to see that he is taking custody and protect the asset and sell the assets and distribute. I'll show you the language also.
Yes.
Liquidator is not given a task of managing the affairs, managing the operations of the company. So there it is there itself for these departments, these people, they are not ready to follow, they are not ready to listen. That itself. They want a liquidator to follow everything. They wanted the liquidator to file return. Section 139 of Income Tax Act says, just for information, I'm telling you, who are
Yes.
facing,
Due date for filing. Due dates for filing.
who are facing embarrassment from all our income tax department friends and GST department friends, okay, who are facing harassment only, I have to say. Embarrassment only. Embarrassment also I should not say. Not even embarrassment, harassment. Who are facing harassment from income tax or any department, I'm saying. Okay. At least income tax, I'll tell you. See, section 139 of Income Tax Act says, if balance sheet and P&L is not attached by the company along with the return, it becomes defective. But here the department serving to all liquidator, okay, all liquidator, at least during CRP, it can be understood. Okay, the IRP is obligated to draw a balance sheet, he has to do compliance, all that is understood, which is written in the law. To some extent, it is written, covered in the law. But liquidator, nothing is covered. Law doesn't give that obligation at all to liquidator. VAT gives that obligation to liquidator. It is not given. But no department want to understand that. Income tax wanted to liquidator to file the return. GST department liquidator to file the return. Okay, I am filing the return as liquidator under Income Tax Act without balance sheet, without P&L. 139 of Income Tax Act says without P&L, without balance sheet, if I file a return, the return is a defective return and liable to be rejected following legal action. Following action from Income Tax Act, which follows legal action, coercive action, recourse action from Income Tax Act. So, but the Income Tax Act wanted liquidator to file. If I file, will it not be defective return? Under Income Tax Act, the income tax officer, ITO, is not permitted to accept that return and if it is a defective return. But here, as liquidator, I am not given a authority or obligation or power to draw a balance sheet or P&L. Are we given the power? We are not given a power.
Authentication is not possible.
We are not given power to draw balance sheet. There's a clear judgment of Honorable Enclad in Om Prakash Agarwal case. Mr. Om Prakash case, there's a clear judgment of Honorable Enclad that liquidator is not obligated to draw balance sheet. He is obligated only to see what Regulation 6 provides for. Nothing more than that. But you say whatever it is. My ears are deaf. Department ears are always deaf. I will simply, I came today morning and sit in the chair as whatever the position I have, I'll serve notice to you. You file return. Read the law. Understand the law. Not that simply coming and just because of your pen and paper and a hand to sign, you can't simply issue notice to everyone. You are supposed to follow the law. But nobody bothers about it. They wanted to file. If I file, what will happen? Return. If something goes wrong in furnishing return, what will happen? Who is responsible? Suppose there is a suppression of fact. Block assessment is there. 8 years it can be done. I'm not expert in income tax. I'm just sharing my knowledge only. Okay, I'll file it. I'll file a return. Subsequently, they are picking up. No, the income is suppressed.
Then who has to penalize? Either liquidator or...
Exactly. You will go and stand before the court. Our friends, insolvency professionals should understand. Our friends, insolvency professionals, very meticulously filing return.
Correct.
When I am hearing, hey boss, please understand the consequence of it. You don't take it lightly. Your entire lifetime will go explaining to the department only. And which you are not at all duty obligated. Because you are filing the return based on the details available with you. First of all, the law does not mandate you to do that. Law gives a different mandate to you. Sell the assets, take custody, preserve it, sell it, make sure that it is properly distributed as per the approved claim, and come to the court and file your report and get lost after taking dissolution. This is the responsibility, obligation given to you. Is that obligation given to you to file all returns Okay, after 3 years, 4 years later, doubts come, and the department feel that you suppressed in your return. Whether department will take against you or against the director. Who will be responsible? You will pay whatever the amount, the demand they are raising. They are blindly giving a demand of 100 crores, 200 crores, when there is no worth of 50 crores also in the CD. But demand is coming for 200 crores, 300 crores from IT. Putting penalty 60 crores. Interest 60 crores. My God, horrible. Okay. So what my request to insolvency professional friends, at least attending here, we have to comply the law. We have to go with the department, no doubt at all. We have to do our duty. No doubt. There is no doubt. Second opinion on that. But all we have to understand, whatever now we are doing, we have obligation to make sure that whatever comes out of it, that also come to us. But which the law does not give that responsibility to us. On our own, we should not take that responsibility of doing it. On our own, should not take the implication of prosecution against us.
Even after the assignment is completed also, they may ask.
Yes, why not? You are signing the return, na? Who signature in the return only, they will take action. When the company in CRP liquidation itself, those deaf ears are not getting anything from us. Not getting any this thing from us, not taking any input from us. They are closing their ears. During liquidation, during CRP itself. After it is over, they are not bothered at all. I don't know, you sign the return, you answer it. Then we have to run to our honorable adjudicating authority and take was there. How many times you will run? How many departments you will run? That too after finishing everything, after nothing in your hand. So please understand the replication of what we are doing. It's not that we are going to be appreciated by you're a good boy. You filed all returns, all done, you're done. It's not like that. Like a student, we can't say that I done my record progress report good. See my progress. Well done. You're done. Contact is good. You're a good boy. Good boy, student of the year. No. Please use. If there's a legal replication behind everything. We are answerable till end. Till that assessment gets over and till the assessment is proper and income tax deem it as proper, the person who is signing the return is responsible. Same way the register of company. Same way for any authority. Whatever we sign and file, something goes wrong, we are responsible for that because we are signing it. Please understand the impact of it. Let's move on accordingly. We'll break for 10 minutes, then again we will restart. Okay. So that let me come out from this mind and go in a different topic, little different topic.
Am I audible, sir? Sudhirji?
Yes, sir. Yeah.
Shall we start?
Yes, you are audible.
I'll share my screen. So, okay. Okay, I'll share my screen. Yeah. See, I was sharing this PPT. Your number is increased to 51. My God. So many late joiners. Okay. I could not take out my PPT. Why? Anyway, then I'll open a file. It's okay, I'll open again. Don't know what happened. See, in fact, I stopped with the 206. Actually speaking, if you further travel, that will scare us only on that particular topic I'm saying. Because there are so much thing is there to understand after 206. Because after 206 only is going to be a big challenge after 206 process only. So it's not that with this 206 some showcase notice we are simply answering and coming out of the thing. It's not like that. Once we allow inspection or investigation to commence, then what will happen? I will just want to show you few things. After that, then I'll move on to next one. Okay. See, this only I was sharing to you. So I'll quickly close this. See what happened after this inquiry, because 206 permits them to inquire detail. Okay, after 206, what happened? 207, they will conduct. They can call for books of accounts and they can conduct the. In fact, here it shall be. Please understand what it says. It says it shall be duty of every director, officer, or other employee to produce all documents. First of all, here also there is no power given to us. And the INB code also there is no power given to us. Okay. Okay. Because it is only given powers to directors and employees only to do that. Because there is no word. See, under section 230, to file a scheme, they included liquidator. Why not they include liquidator here, 206 also, if the obligation should be given to liquidator? So that means there is no scope for liquidator. I'm saying even RP, IRP, I'm saying. Okay. It is only for the director. In fact, the even section says if a director disobey, but suppose the IRP, RP disobey, what they will do? But showcase notice is issued. Then we have to go into the court only and fight it out. Okay. Problem is that only. So now why I have to take it further? After that, what will happen? After inspection 208, 209 gives powers to seizing the document. Okay. Then that means they can even seize the document. Can we allow? No, we can't allow. Because once it starts with 206, 207, 208, that percolate into 209 also. If required, they will seize the document with the permission of special court. Okay. Then in which case, how we can share the document when we are given an obligation to revive the company, or when we are given an obligation to liquidate the company under the supervision of another adjudicating authority? So we cannot give. So later running to the court, adjudicating authority and cry that see wanted to seize my records and all that. See, I'm only doing CRP and liquidation, it's not running company. Then better to stop them from initiating after making them to understand the provision of the insolvency code and the power of the insolvency code and what it provides for 238, all that we should make them to understand. So these are the investigation can be started. So on report of the registry under section 208, why I wanted to show particularly this only. On receipt of the report of the registrar, because after 208 inspection, a report will be shared by registrar. So after the report, then central government may even start investigating the affairs of the company. So once we fail to stop them in that stage, explaining the legal provision, what is the obligation in IRP or RP and liquidator has got, and make them to understand what exactly as insolvency professional we can do. Unless we stop the process or put past the process, need not to stop also, we can put past to the process. Please, I will give some time. Why law gives moratorium to us? Because we should not unnecessarily get into all this kind of procedural thing and process thing, okay? Because our focus should be on only on revival. Why business has gone to this level, what spoiled the business, and how to revive the business. So that task only is given. So what lawmakers or legislature wanted us to do is that don't shut the operation of the company, because once you shut the operation, there's a lot of implication on that, because more of workers will be affected, employees will be affected, and the materials and factory and many things are there. So for that reason, they said you manage the affairs, you run the company, keep it as a going concern. But here, without understanding this, department sending notice, I will do inspection, I will start doing this. Then what will happen? 206, 7, 8, 209, then 210. If investigation orders, what will happen? Then SFI will come and sit. They can do, when we permit inspection, then automatically next course of action is investigation. They may also feel that no, we have started the process. Already we have done inspection. Now you can't stop me. Let me investigate also. So what will happen after investigation? The entire process will follow. Then they will freeze. What they will do? The functions and powers of SFIO, I'll tell you here. It's very important. More than anything, it's very important. Okay. If a director, additional director, this level, all this, if they have a reason to believe, means the SFIO officers, if they have a reason to believe, okay, that any person is guilty of offense punishable under section 447, he may arrest that person and before judicial magistrate. So please tell me now, if inspection is initiated, okay, and the scrutiny is done, inspection is done, investigation is done, in case the government felt SFIO investigation has to be done. I'm saying doing CRP, I'm saying. Even liquidation also they may do. Today the mood of department is that any department I'm saying, I'm not bothered anything. My law says my respective act impose me to issue notice to you, do anything. Okay, I'm not bothered about your 238 and all. Okay, because I'm keep writing letters like anything. 238. Nobody bothers. I'm not bothered your 238. I bother about my own act. My own act permits me to sign and issue notice, I will issue. My own act permits me to conduct inspection, I will do it. So my own act permits me to do 1, 2, 3, I will do all 1, 2, 3. I am not bothered, and this is the attitude we could see in our practical practice, or in our liquidation process and CRP process. The approach of the departments I'm saying, which we could able to see their approach. In that case, if they start all this and proceed all this, then SFIO in case come, my question is that if suppose the violation, whatever the violation, I told you about, take it for example, 20 offenses, 10 offenses prior to our offenses, or you take it as a non-compliances. Okay, let it put it that way, non-compliances. Okay, non-compliances, 10 pre-CRP, 10 post-CRP, during CRP. Due to certain practical difficulties or due to non-cooperation, there may be a number of reasons. But in which case, who will be arrested? That is basic question. Suppose SFIO felt, yes, there's a reason to believe that something has materially taken place. There's a violation. Who will be arrested? RP, IRP or liquidator will be arrested? Or directors will be arrested? Who has to take the responsibility? Well, because they will say, no, my powers are suspended. No, you can't say. Simply they will walk away. Promoters, simply they will walk away. By simply quoting, no, we are suspended, we are completely out. Nothing is in our hand. As if everything, when things were in their hand, they completely made a wonder. See, because of their mistakes only today, our professional, insolvency professional has to sit and see what can be done. But today, they will say, no, nothing in my hand, nothing, we don't know anything, we are completely out of reach. We don't know any document, we don't have any document, nothing. How can you can come and ask me? We don't know what RP done, IRP done, liquidator done, everything they only done. Simply they will throw the ball to us. Then who the SFI officer will arrest and take in case of any violation that had been unearthed during the investigation? Because at least in 1956 Act, that power was not given. At least, okay. 1956 Act, SFIO was not part of the enforcement authority. SFIO was only and referring, they were only doing as a assistance to MCA, because SFIO is formulated by virtue of a circular by MCA. I'm saying pre 2013 Act. SFIO was only assisting MCA in rendering investigation. They will not they will not take action at all directly, because they were not given that power at all earlier. But today, after 2013 Act, that's the reason I gave the background of why 2013 Act now completely redrafted with a lot of stringent provisions and lot of prosecution provisions and imprisonment and penalty amount, huge penalty amount. Why? Because seeing all that scam, government to change their mind. We don't need a simpler Companies Act. We need a draconian Companies Act, or whatever we call it, a tough Companies Act. Okay. Then they brought it. They gave a power even to SFIO. SFIO is given a power of police officer. He can arrest a person directly, produce before the judicial magistrate. Even he is given a power of to file a report under section 173 of CRPC also. That power also given to him, because there is no police involvement in between. Directly he will say, he will file a police report, he will directly produce before judicial magistrate and remand. See the power given. It is not simply allowing the inspection, allowing a document scrutiny. What it will percolate, that's why I told you. It's not simply filing a return. Where it ends, we have to see. It is not signing a single document, what our department asking today, or any person insisting us today to sign or want us to do. We need to comply only, no doubt. We have to follow the law. There is no doubt. Who has to take the responsibility of it? For the action, for the act which is not done by him. We have not done anything. We have not acted. Company was run by somebody. He was not doing properly. Now today it is given in our hands by the court. We are trying to find a solution now. For that matter, whatever mischief done by the earlier person, that cannot be faced by the present person who was appointed by the court, who literally appointed to revive it and find a solution. That's the reason that, see, the lawmaker is very clear. The code is codified okay, properly. Code is not permitting many things. That's why I'm showing the difference. See, this topic need a full day deliberation. It's not simple. How we are deliberating, just comparing, seeing this, whether balance sheet should be filed or not, whether RP can sign or not. All this is basic things. I don't want to talk about the basic things, whether RP is empowered to sign, only board is empowered to sign, whether RP is empowered to sign. All the circular came that even the income tax also, they introduced something through a backdoor entry, they introduced something. 140 of income tax is amended through backdoor entry. Because you see the section only empowers RP, IRP and the section 140 to file a return. means under the income tax provision. Only IRP and RP, the word is there. Only IRP, RP is empowered to file a return. Okay, then through a backdoor entry, income tax has amended a rule. They brought liquidator also into them. Knowing the difference only, the lawmakers have done it. Without understanding what is the impact, what is the difference of CRP and liquidation. By rule, through rule, they are introducing a liquidator within the scope of the filing of return. Then they're saying, no, you have to file the return. We will not return any refund. We will deduct everything. You have to file return. We are not bothered about liquidation. See, our rule says liquidator also not. First of all, law, Parent Act itself is not empowering. By bringing a rule, something is doing. So like this kind of game only is getting played by departments. They are not here to help us. They are rather complicating the show. Because one man, after doing a course, after passing examination, after following all the rigorous process and meticulous training, and given a responsibility by the Honorable Court to see that how it is revived. All these people have, without understanding what is the significance of it and the significance of a person who's sitting there, simply writing, simply sending something without even bothering what is the application of it, whether it will go against the very spirit of the code or not, I am not bothered at all. What you will do? That there maybe their assumption may be that what maximum you can do, you do. Anyway, court is there. I will say I have done my duty. So code is very clear. Code is codified properly. What IRP has to do, what liquidator has to do. All the department, other stakeholders, they only should understand properly the code. Not even understand, they only should follow it actually. But rather they are following it, they are complicating it. That's why most of the RP and liquidator are running pillar to post. Without nothing, means without any result, I'm saying. Even sometimes without money also, many of the IRP liquidator may be suffering. Without money also. That responsibility also nobody will take. Fund also. Okay. So in this background, if you want to face all this investigation, all this, then what will happen? Who will bear the cost of it? Who will go behind it? So we have to understand the seriousness of it. Today, in fact, the one show cause notice, what I showed it to you. It is not just show cause notice. Please understand today what is included in the fraud definition. I wanted to show just fraud definition alone, nothing else. That's why in 300 odd PPT, I'm not showing everything. Yeah, that's all basic things. These are things where we are directly affected. We may get affected. So that should not happen. That's the reason let's have basic understanding that we should do what we're supposed to do. We should not do what we are not supposed to do. It is not that what is that anyway, I'm free only. Anyway, what is going to happen is simply asking something. Nothing wrong in following. Oh, then please read this.
Sir, we can get this PPT, sir, if you don't mind.
I'll show you. I'll surely show you some 300. Every half of the company, not half, almost 90% of companies act is covered in that. Okay.
Okay.
So I can share you also. Okay. See here you read this, the fraud definition. Any committed by any person, in fact, in the interest of not only the company, in the interest of shareholder, in the interest of creditor, in the interest of any other person, then department also will come into that. It is not only the company, not only the shareholders, not only the creditors. If it is against the interest of department, then they will say, no, fraud says that you have committed against our department, so you are liable to be prosecuted under 447. What is the impact of 447? Imprisonment not less than 6 months, which may extend 10 years. My God. Why? But today I'm saying our duty is different. What we supposed to render is different duty. What people are trying to, out of ignorance, what department want to pull us inside is here. Same way we can show in Income Tax Act, we can show in GST Act, what are the application of, wherever they are trying to pull us inside. Without even authority that for pulling us. And without an obligation for us to go into that. We are not given that obligation at all, but they will make sure they are pulling it. Because of this, what happened? Even that 468 bar also is taken, because that up to only 3 years only we get this protection, period of limitation. So now that limitation also will be lifted. So after 10 years also, Aram they can come and take action. See, the director replied saying that during that period he is suspended. During the period of 19-20-20, he is suspended. That time you only were signing all the records, and now only we produce all the records. Now company has revived, everything has come now, become back to feet. So company is running, but the offense, what is committed, got committed or something got wrong, is in the year of 2019-2020. That time you are in charge, CRP. You are a RP at that time. For 330 days you are acting as RP. You only signed all the papers. You are given an obligation of complying the law. Therefore, I can't take action against the director. Since you have signed, I can take action against you only. Because there is no limitation. If limitation is there, at least within 3 years they can come and take us. At least we can answer. After 3 years, you can't take action because the imprisonment is more than 3 years. Earlier, 1956 Act, the imprisonment of more than 3 years was not at all there. Only 3 sections were having more than 3 years. 628 of 1956 Act, 629 of 1956 Act, 207 of 1956 Act. Only 3 sections are having. Here, because every section is liable to come under the definition of fraud. Because it says any act, anything done against the company, against any person. So anything can be brought in today. So this is the legal implication of it. Please understand, we can't take it lightly and say that no, what is there? Just written only we are filing. What is there? Let's file. We will see later on what the big deal. What big deal? Heaven is not going to fall down. No, it will fall down on you. The sky will fall down on you only when you sign the letter. When you sign some paper. Without authority or without having obligation to sign. If we have obligation to sign, then okay. We have to take it. We have to be meticulous in following the law. We are given that responsibility. We have to follow the law, and we have to see that we are rendering our duty properly. And we have to sign the papers or documents, whatever we are to, the document have to be signed by us. We have to sign it, no doubt at all. But not simply some department is asking, somebody is asking, no, you have to do my act, my parent act says like this. So, you see the code. That's why it's a code. That's why I started with why I started giving brief introduction on Companies Act and code. Because it has got a difference. Code is a prime. It is a big boss. But nobody understands. Nobody understands. In fact, the departments are treating code as a servant, not even as a boss, not even as a big boss. It is treating as a servant only. No. I will issue. You do whatever you want to do. You go to authority, you take action, whatever you want to take. I will issue. First of all, where you can issue, you can't issue. There's a legal bar. So 238 is giving a legal bar that you should not do in contravention of the provisions of the code. After doing it, you do whatever. What is this? So that means people are knowingly they are doing. So it is our duty to see that we are rendering our duty properly and not unnecessarily getting into any complications. So you see what is the authority given to us. Here, I'll show the difference between the RP and liquidator. I'll show the difference here. See, under 23, if you see what are the responsibilities given, same the responsibility what is given to IRP, the same responsibility is given. Okay. Let's understand what the difference between the IRP liquidation. Now we have understood, we have tried to understand the difference between the other laws and IBC. Now let's try to understand what the difference between RP and liquidation, between CRP and liquidation. Okay. Both are not same. Please understand, both are not same. Totally different. Okay. Now, what we supposed to do? As a resolution person, he has to conduct entire corporate CARP, manage affairs of the corporate. It says you manage the operations. Why it says manage the operation? Because if operation stops, Employees may lose job, employees may not get salary, or the factory, if it is not run properly, it will go deteriorated and rusted. So see, you want to keep it live because company has to be revived. That is the idea. Okay, it's not that supplying detail, whatever done last 20 years back, you supply all the detail, I want to do this. Where you are doing the sleeping. After sleeping 8 years, during liquidation, show cause notice they are issuing. Right? How could after sleeping 8 years, 10 years, you can issue now? That too when a company under the supervision of the court. You are issuing notice to the company which is under supervision of the court. Nobody bothers. Okay? I will issue. You reply or you whatever you want to do, you do. You are deemed fit. I will issue notice to you. So it is only the insolvency professional who we have to equip ourselves. It's not that we should expect others to behave or conduct properly. We have to understand and we should know how we have to conduct as per the code, as per the obligation, duties and responsibility given by the code and authorities to us. We have to do that. Not because they will behave how they want to behave to their advantage. The outsiders will behave. Okay, whoever it is, the outsiders, whoever it may be, they will behave on the way how they want to behave to their advantage. They are behaving. So as a profession, we only should understand what we are obligated to do and what we are supposed to do. Then only we can smoothly do our process, CRP process or liquidation process, and we can follow the rules and norms, and we can come out from the matters after executing the responsibility given us by property. Okay. So now here if you see the whatever the responsibility given to the IRP, same thing is given to RP also. That's why I wanted to show you that is the reason behind it. That's why I'm showing this. Okay, it shall be duty of the RP to preserve, protect assets. I told you. Okay. It is the duty of the RP to preserve, protect assets, including the continuous business operation. So whatever continued business operation, that has to be preserved. Okay. Then take custody and represent to the corporate data, raise finance, okay, appoint professional. See, here, you see here in duties, see the difference between the duties. Duties of IRP and duties of RP. I just want to show the difference. See, IRP is given a duty of collating because he is only doing the first 30-40 days job, whatever the collating. So he is not given. His primary duty is to constitute committee of creditors and monitor the assets and manage its officer until RP is appointed. Now, after RP is appointed, what is the duty is given to RP? Sorry. See, the duty is given to RP is that preserve and protect the assets, whatever taken custody by the IRP, okay, and whatever, then take immediate steps to make sure that representing the corporate data, rising fund, maintenance of the all these routine things. Then what they have to do, invite resolution applicant. In fact, the law says that you start doing revival process. It only says you have to start immediately doing revival process. Okay, no other obligation is given because there is no time for anything else. See, that is the reason. See, the RP shall exercise powers, duties as are vested or conferred. So it is not that whatever given to IRP, it gets over with that. No, the RP is extended arm of IRP. So he has to make sure he should conduct operation. You should conduct entire CRP and manage operations. That's why I said. Here it says manage operations. Can we see the difference between the both? 17, if you see, management of affairs. Okay, management of affairs. 25 gives duty, okay, but not 25, 27. it only says this only I wanted to say. Here, this only says that to manage the operations of the seed. Okay. It only says manage the operation. Where there we see manage the affairs. I leave it to you. Is there any differences there between the both? Okay. Anyway, there's a regulation, there's a separate regulation, manage IBC, CRP regulations, which we have to follow, all that part. But what the court says, I'm saying, it wants the, but of course, RPA has got same obligation what is given to the IRP, which I showed it to you also. Okay, it is not that RP is free. Whatever done by IRP is not the part. No, RP is nothing but he is given an obligation to make sure that he is managing the affairs. Okay, and he is given a responsibility of IRP. No doubt at all on that. But here it says manage the operations. Okay, and the shall exercise powers and duties as are vested and confirmed. Then we can say that as per this, you have to follow everything at all. Okay. Now, why I have to highlighted this? I'll tell you this. Manage operations. IRP affairs. Now you come to 35. It's more important. The difference is more important. Because without knowing the difference, people are doing drama like anything else. Every department, everybody is doing drama like anything. See here, liquidator shall have following powers and duties. Okay. See why under IRP, RP, powers are given separately and duties are given separately. IRP, RP, powers are dealt with separately. Okay. Independently, it is dealt with. But in liquidator, the powers and duties only one section. You do this, okay, subject to direction of adjudicating authority. What are that? To verify claim, to take into custody and control of all assets and property, evaluate the assets, take measure to protect the assets, carry on the business of corporate for its beneficial liquidation. It is only for liquidation purpose only you are doing it, so that you gain more. If it is running kind of company, that's why corporate going concern concept has come in liquidation also. Why it has come? Because if it is a going concern, you may get better value. For that purpose, you make sure that it is the business are managed for a beneficial liquidation, not to run the company like a regular company. Okay, to sell movable immobile. Okay, this is a power is given. Okay, to take official. Okay, to obtain professional assistance, all that. Invite institute, here to institute, invite all that with the direction of honorable adjudicating authority, no doubt at all, to investigate into affairs. We can investigate. Can we allow the department to investigate? That's why the law gives power to the liquidator to see that the liquidator investigating the financial affairs. If something comes in his knowledge, he can always report to the department. These are the things I have seen it. The action may be taken, or the same can be taken up further. Okay, but that obligation is also not there that we have to report. But we have to investigate to make sure the provisions of the IBC code is properly complied with. Then to apply adjudicating for us. Here, I think here how many? 32 is there. My God. Oh, 32, not. I showed here, now you see how many is here now? Participant, 53 participants here. Okay. Living in shooter. Take 50 at least, okay, around. Out of 50 participants, I'm asking, where here the liquidator is given power to manage the affairs. Where is the responsibility or powers or duties given to manage the affairs. When you don't manage the affairs, how you can give the details or file a return or do anything? Any part of compliance can be done with respect to these things, not for running, not for running and maintaining for managing the affairs. No, because that powers are not given to us. That powers and duties are not given to liquidator at all. Without giving a power, how a liquidator can file return, liquidator can do X, Y, Z, whatever, what not. A to Z, they wanted IRP to, RP to do, liquidator to do, and they will sleep 10 years together also. After IRP, RP or liquidator appointed, they will wake up and they will sign notice and issue, I want to see that year. That obligation is not given, it is under court control. Suppose a show cause notice is issued to a liquidator. Is it on the liquidator or as a court officer? Because liquidator is RP, IRP is a court officer. They are representing the court. Because court only is giving a direction. See, the RP, IRP and liquidator are executing the direction of the court on their own. Nobody is doing. If some action is taken, some show cause notice issued, it is issued to the individual or to the court. To whom it is issued then? Who will be taken for the task? One court will issue notice against another court or what? See, this is the road code is codified properly what should be done, what should not be done. Here, by seeing individual name, okay, individual is that, we will write something to them. Issue warrant also. I have seen cases where warrant and all getting issued to liquidators and IRPR. What do you want actually? Read law properly. If you don't, earlier at least you never read the law, at least now you read before issuing warrant. Is the liquidator given a task of going and attending a criminal court for the misdeed done by the director and represent, and then liquidator, how he can do what are the responsibility given under section 35? If you go and stand before the court and execute every presence and attend every hearing before the criminal courts. No, but warrants are issued to liquidator. Name is added in the friends are telling, I got some notices. Why? That's what I'm saying. We have to see that the law should evolve with much more clarity. I'm saying the Companies Act has to be touched upon in every chapter, every provisions wherein there should be a clarity between the running company, between the company which is coming under the jurisdiction of the IBC. In fact, everywhere it has to be touched. I won't say that here, there, and there. Everywhere it has to be touched. In fact, we can take right from section 1 to section 470 of entire Companies Act provision and say, entire provision we can touch upon and see that where and all the provision should be touched upon and see suitably it should be modified. So that all these department people, when it is in writing itself, they are not ready to understand. They don't want to understand. When it is specifically, expressly given in the law, then itself they don't want to understand. When nothing is in the law, then how to convince them? Then unnecessarily they are dragging. How many cases? I'm sure that most of the RPIP sitting here, you must be having many cases. If you have 10 cases, out of 10, 5 must be from the department statutory authorities. Is that after understanding the law properly, they are filing the cases? Is that the way? See, affecting the rights, some stakeholder is filing, it's okay. Section 65 gives them power, aggrieved party, do. Department, why? Why there's urgency? Sitting in the 5th position. Section clearly made it. Very clearly it made it. Okay, Companies Act clearly demarcated, though it gives higher priority to department, but in liquidation it gives a 5th position only under section 53. Then why they have to show the same legacy, same urgency, and same authority? Authority more than what law provides. That too against the provision, in contrary to the provisions of the INB code. Why? So I think they have to understand, or my request to all IP friends too, represent and please make them to understand rather thinking that I am cooperating them. Okay, then please cooperate them. Go till end, see what is the replication of it, then come back. No, nobody will help us. Because once our duty is over, then who will help us? Nobody will help us. After we dissolve the company also, Aram say he will issue notice. Okay, then we have to face. So better see that what is permitted under the law that we are doing it and give answer to authorities or stakeholder, whoever it is, that please don't ask me to do beyond the boundary or beyond four corners of law. What law permits, that alone I can do. So this is the lesson that we need to understand from INB code. INB code is properly drafted. I won't say code, no, in fact, it is properly drafted. If it is followed itself is enough. More than INB, touching upon the provisions of INB code, rather I would suggest to touch upon the provisions of Companies Act only more. I can take every Companies Act provision and tell the impact of it. Because the company which is under CRP is not the company, is a regular company which has to follow the entire 470 section of the Companies Act. No, it won't happen that way, because here the responsibilities are different. Here responsibility are different. Here he has to manage the affairs of the company. Here he has to make sure the resolution plan is given and plan is verified, report is given, it is presented to AA, then adjudicating authority has to approve it, and he has to make sure that everything going proper. My God, how much big task is given? Then liquidator to see that asset is claim is collated. Even in claim also, Aram say 4,000 days delay they will file claim. That also we have to go and represent before the court. Registry supposed to throw it out, actually speaking. When law is there, why you are coming so late? Even appeal itself, they are filing delay. Law says within 14 days you go and appeal. I will file an appeal against liquidator section 42. I will file 90 days. Anyway, court, they are taking condoning now. I will try with the court. Why? Then why court has to give timeline then? Then number of cases adding. For claim some 10 cases, for department some 10 cases. Promoter, default case from promoter, default case. If you are not having any case from promoter, then you are lucky. Okay, that is an exception. Don't take it that is a regular normal routine. No, you are under exception. Okay, friends who are having case from promoter is a regular. Because promoter will file a case only. Naturally, he has to protect his thing. He has to file a case only for that. Okay, so how many cases? Then how this task can be achieved then? What are the role given to IRP right from section 15 to section 33? How all this can be achieved? And how the liquidator right from section 33 to section 52? How that all those requirements can be met out by liquidator if he keeps on going and standing before the court for cases, keeps on answering the provision which are expressly there in the law. At least you are going and replying to the department or stakeholder, which is not there, at least okay. Fine, we are under obligation to make them to understand, explain them, understand. The law is very clear. That itself have 10 number of cases. That itself will have 10 number of issues. Law is very clear. No, I will not follow. You right. I will again start. I will issue assessment. If you don't cooperate, then I will do next best judgment assessment. I will issue on my own notice. Then I will issue on my own penalty notice. I will issue on my own interest notice. Then I will simply, make it add up and bring it to 500 crores claim. My God, it may not even worth of 15 crores. 1.5 I'm saying, but 500 crores worth, because officers, they want to do their duty properly, because they have to show to the higher authority they are doing their job. Okay. So they are doing their duty. So what happened? IRP or RP or liquidator has to go and fight before the court and see that this claim is not valid, then where's the time for other things? We have to sell, then after sale also case will be filed. For everything case will be filed, then where is the time? Then 180 days now became, after that law gave 90 days time. Then after 90 days also again law gives 90 days time. Now 330 days time, including all litigation. Where? See the statistics, how much time it takes because of cases. How much time? Cases also is not really potential cases. Aggrieved. If one is aggrieved, then remaining 9 cases out of 10 all are simply dumped, fake. Simply they file some cases. And they hear and takes time. Then till then nothing could be done, because our rule has to go by principle of natural justice. So that we have to go by principle of natural justice. So everybody question, concern has to be addressed. Then how it can be done within 330 days? That's why it is stretching more. Because we have to address every points, every queries of everyone. Because it has to go by principle of natural justice. Yeah, section 425, I'll show you that. Actually, this is also important provision that you have to see. Okay, so one important thing is that though NCLT has emerged out of Companies Act section 425, but NCLT given additional authority of handling insolvency bankruptcy code also. The same, fortunately, there is no separate same thing, so that both Companies Act and IBC can be the same. 425 we can easily see like that. It is taking a lot of 15. Okay, power to contempt. Okay, so this is the only provision which literally gives us some relief. At least now, earlier Company Law Board is not given that authority. Now at least our Honorable NCLT and NCLAS is given this power. The tribunal and appellate tribunal shall have same jurisdiction, power, authority in respect of contempt themselves High Court. Little saving our time, because order little will be respected. Otherwise, that also we would have faced difficulties. Because now, because of this provision of Company Act 2013 of giving a contempt power to tribunal, now at least to some extent we could able to breathe and see that some orders we are getting and we are doing it. But only thing is, all I am trying to say is the time is taken more. Our time is getting wasted more in by not doing productive things. By not taking productive steps by IRP and RP and liquidator to make sure he is rendering his responsibility duties as per the insolvency code properly. Here the only challenge. Now coming to section 230, I want to take you to 230, because this has made a lot of changes it brought. See, that's about searching taking time. Better I can scroll and get. See? Here, why I wanted to do. Now, fortunately, that's why I said the code has brought everything inbuilt. Now we have to see that how these things are properly, synchronizing and properly touched upon to make sure the difficulties are not faced by the stakeholders or insolvency professionals or courts or. Here you see. Here this is the important thing, which created a third what to say segment, because we all know one segment is CRP. Okay, the next segment is liquidation. Correct. So one third segment got introduced under the Companies Act. Why? By virtue of this particular provision. Power to compromise make, of course, I told you I'll give half an hour time to discuss, but I have more to cover. Let me see. Then finally we'll see. If we have time, we'll discuss. Because I should not eat time of next speaker also. Fine. See here, this is very important thing. Tribunal on an application of a company creditor member in case of company which is being owned up of the liquidator. Okay. Here, this liquidator is a court liquidator. Means the liquidator office which who earlier who were under the control of High Court liquidator. Okay. By an introduction, they introduced a liquidator. No. Okay, that liquidator, this liquidator. What is the same word liquidator? Appointed under this act or under Insolvency Bankruptcy Code. So this gave a clear way that, oh, then IBC also can do. They introduce a new segment. A scheme also can be proposed by liquidator. I know many of you might have handled also, because when we say interplay between the IBC and Companies Act, we have to see where and all the both provisions are touching each other. Okay. An application made appointed by under this the liquidator appointed under Insolvency Bankruptcy Code is also or may also take steps. Can also take steps. We can put it this way, can also take steps to file a scheme under, or is permitted to file under scheme. But of course, that after it became duty obligated to under rule B or 2B, you must know regulation 2B. I think you would have seen it or not. I show you that's a separate slide for that. Okay. This slide. This is on corporate restructuring. So these are the things where Companies Act and yeah, that's what I thought. Okay, when I discuss about corporate restructuring, because when corporate restructuring comes, earlier we used to discuss only under the Companies Act 2013. Now the topic corporate restructuring now not only the Companies Act, it can be now done under the Insolvency Bankruptcy Code also. That's why I prepared a separate PPT also for that. See, Insolvency Bankruptcy Code, see, you all know that from May 16 it has came into effect, and after amendment all that it has come. Now, very importantly now, I was showing this provision 230. Okay, the section it got notified in you see now resolution plan under section 5 and class 26 resolution plan. What happened? By virtue of the word language liquidator appointed here, liquidator, I think I should show this way, no? And you can see better. See, by virtue of this word liquidator under Insolvency Code, I showed you in the Companies Act 230. By virtue of this, what happened later? Resolution plan means plan proposed by resolution applicant for insolvency resolution as a going concern in accordance with part 2. It is clarified that resolution plan may include provision for restructuring of corporate debtor, including by way of merger, amalgamation, demerger. That means there can be a plan which can provide for even restructuring. It can also be in the form of merger, amalgamation, demerger. Don't ask me difference between merger, amalgamation, demerger, because that difference itself we can talk half day. That itself for some 5-6 hours we can deliberate. So much is there to understand between merger, amalgamation, and demerger itself. Okay. So let's not go into that topic. But plan can be proposed, including covering merger, amalgamation, demerger. Okay. Now, all this is plan can provide for transfer of all assets because the regulation provides for. Now, in regulation 37 of insolvency, resolution process for corporate restructuring of corporate data by, again, in that regulation, it is included. Regulation 37 of CRP is included. Restructuring of corporate data can be done by a merger amendment. So this is in addition to this. Because here, if you see, this is on definition of resolution plan. Okay. This is on regulation. So, because the section already giving enabling provision, so the regulation also has brought it. Yeah. Now, what happened after this? The court started, deliberating on the Honorable Enclat and Honorable other courts in Binani Industries, Bank of Baroda. They clarified the objective, that objective is that resolution only. Why this particularly the concept has come, that we have to understand. Why this concept of third segment, which I called, has come, because the courts were under the impression, okay, are they on their, by reading the insolvency code, the Honorable Court has understood that liquidation is not the final climax of the IBC. Revival is only starting point, should be the climax. Liquidation should be end, unless otherwise. So why we should not introduce another revival process? Suppose the plan doesn't work, why scheme should not come? But already plan itself provides for scheme. Apart from that, again, scheme also being rendered, means that process also means that steps also taken by our friends, liquidator friends and RP friends, that as a separate segment. So then maximization of asset, all that is deliberated in the order, and promoting entrepreneurship. This is the only motive of the court. Therefore, in Jurisprudence, what has happened? Honorable Supreme Court has said that the purpose of INB code is to revive only, not for liquidation, because even the object of the code itself does not sound about liquidation. Object itself does not talk about liquidation. Object talks only about revival. That means the code itself is for revival only. Therefore, whatever possible, the concept of selling the corporate data as a going concern should come. Then only the object of the code will be achieved. That's what the observation made by Honorable Supreme Court. Then Honorable Enclat and the matter of S.C. Segan, Amit Gupta, they came out and said liquidator to initiate the liquidation process. Then next another Kate Vaiswaram Prasad and Dhanapal, and they said they gave a direction. Honorable Enclat has directly given a direction saying that the liquidator is required to act in terms of direction of Honorable Appellate Tribunal and creditors, and see that the scheme is filed before the authority, and the process and the whatever the section 230, provision of 230 has to be followed. Here only the synchronization has to come. So scheme is filed, it has to be done under section 230. Problem is 230 gives lot of requirements actually. Now one by one, honorable courts and departments are one by one, they are trying to exploring and trying to see that approval. Few things they are exempting, few things they are taking approval. So problem here is 230 you have to comply. 230 is giving a different legal requirement, different process, different compliances. But how it can be done under the provisions of INB code, both has to synchronize each other. Till now, there is no provision which enables synchronization between, convergence between the companies at the INB code in case of corporate restructuring. Except that one word, liquidator also can file. Can file, but when company in CRP, in resolution plan, what will happen? Suppose when the company in liquidation, because rule B2B has come, during liquidation also the liquidator first duty is to see that scheme has to be brought in. Then how could all that 230 requirements can be followed? So there are a number of questions are coming in. What can be done, how it can be followed, then there will be a violation, how notice should be given or not, the creditor should be involved, then who should be involved, because creditor standing in fifth position under 53, now how they should be involved, should be equally given importance. So many questions are coming up in that. Because after this Honorable Enclat orders, our regulatory authority has introduced regulation 2B, you all may aware. You all must be knowing this provision. where a compromise management is proposed under 230 shall be completed within 90 days of the order of liquidation. The time taken on compromise amendment or not taken shall not be improved. Any cost incurred by liquidator, this provision has come. Okay. Now what happened after this provision? Now liquidator is expected to see that a scheme is proposed, it is filed under 230. See, this is a scheme under 230. Then the next question comes, then entire provisions of 230 has to be followed. Okay. If suppose few provisions of 230 could not be followed for want of compliance of code, then what is the legal cause? So all this court has to only decide and take. But there's a third segment has been introduced for scheme, but it lacks synchronization, I'm saying. Convergence is lacking. Okay. There is no convergence in took place so far for scheme. But scheme, though it can be contemplated, it can be filed by liquidator appointed under IBC, but still the liquidator or the scheme proponent has to make sure he is complying the provisions of the entire Companies Act to make sure scheme is approved. That's how it's sound. So that's why different kind of orders are rendered by honorable courts. So every orders are different ways. So it goes with, but there is no synchronization in the code and Companies Act. That's the point which I wanted to say. Now you all know that cross-border merger also has emerged. Now today it is not only a cross-border merger. Now even cross-border insolvency also is evolved. That there also some synchronization is required. But anyway, this is on. Yeah. Now coming back to so 230. So here this only I was showing to you. So here we need to see there are section 230, 232, 233. 233 only is operative thing because 230 talks about scheme. It is a scheme of arrangement and compromise. So that means, yeah, I will show you what it is. If you see the language of 230, it starts with a paragraph where a compromise or arrangement is proposed. So starting point is only 230, but depends on which kind of arrangement, then 230 won't come. In addition to 230, 232 also to be complied with. It is not that sufficient that only 230 is followed, complied with. It has to be ensured that in case of merger, which 232 also is followed. But there is no single language of insolvency bankruptcy code and compliance, exemption, except nothing is there for the entire 230 to 235. So scheme is little challenging task because of lack of this synchronization between the Companies Act and IBC. Now, if I'll be failing my duty, if I don't take you to wherever under Companies Act insolvency is there. But let's see first. Because I'm trying to cover up entire 2013 Act wherever the word insolvency introduced. So that as of today, where and all the provisions of Companies Act is touched with respect to insolvency bankruptcy code. Okay. Winding up means the liquidation under insolvency bankruptcy code. Okay. Now there's an inclusive definition. Now same way here also under formation of charitable company also means section 8 company we call it. There also they said that criminal may insult the creditor to be insolvency fund. They are using that fund. Okay. Okay. Now 66 again coming. Reduction of share capital. Here one clinch they kept. What is it? See, here what they are trying to say, where the name of any creditor entitled to object reduction of capital under this section by reason of his ignorance of the proceeding. Ignorance of the proceedings for reduction of their nature or of their nature, okay, or effect with respect to his debt or claim. Debt or claim, creditor, okay, not entered on the list of creditors, and after such a reduction, the company commits default within the meaning of section 6 of INB code in respect of the amount of its debt. Without considering is if the reduction is done, then section 6 of INB code comes for rescue, then he can exercise the rights given to him. So here they are touching upon that. Okay. Now, again, coming to 77, this due to a registered charge, you all know that the charge has to be compulsorily registered and the Companies Act in the section 77. Okay. Here, the provisions of Companies Act is touched upon, notwithstanding anything contained in any of the post, no charge created by a company shall be taken into account by liquidator, that liquidator under Companies Act earlier. Because this is nothing but same language from 1956 Act following. Okay. Now it is not that liquidator, even liquidator under appointed under Insolvency Bankruptcy Code also is obligated to make sure whether the charge, to ensure whether the charge is registered or not, to deem a person as a secured creditor. Because only it is a duty given on part of the company creating a charge on the property on the asset to register the particulars of charge and charge holder. Then he creating a charge and payment of fee. So it is the duty now given not only to the liquidator and the Companies Act, liquidator under IBC also has the same duty obligation or duty bound to comply the provision and make sure he is also following the provisions of section 77 to reckon a charge is registered or not and to take into account for the purpose of claim and other matters. Okay. Now, next. Now, same way the resolution, whatever passed on winding up, voluntary winding up, under section 117, it has to be filed under code, insolvency code. Okay. There is a introduction that it is not only because now under section 59 voluntary, because earlier we used to do under section 433 of the Companies Act. Earlier under 1956 Act, we generally do all winding up under section 433. Okay. Now, of course, after Companies Act 13 came, it became 270, 271 and 272, we started doing it. Now, voluntary liquidation, they separated and there's a separate section under IBC under section 59. Okay. Now, the action to be taken pursuant to. If any company body capital is liable to be owned up under this Act or under insolvency code, it appears in the government from any such report by reason of such as the circular may, unless already being owned up, cost to be presented to any person. So here also, whatever the out of inspection report, if anything is there, liable to be wound up. It is liable to be wound up. See what the provision originally brought in the original Act. I said it is carry forward from 1956 Act to then 13 Act. Now, liability to be wound up under Companies Act alone should not be considered. Now, even company which is liable to be wound up under Insolvency Code also to be considered. So this is the amendment that they brought in, that if any report comes, suppose already they would have conducted inspection. Now the company would have come now inspection. So in these circumstances, how to deal with that? So that is the scenario here. The petition can be filed for winding up all that. The scenario, what is applicable originally to the Companies Act, same scenario now can be followed under INB code. That's what it says. Now, this only I showed you some time back, 230. So liquidator appointed under the Insolvency Bankruptcy Code. Now scheme can be proposed. Same way on liquidator appointed. This is a two introduction. Except this two introduction, the scheme is not at all touched. There is no synchronization between the IBC and the Companies Act. Okay. So these are the restriction where whatever the Companies Act winding up come, they introduced, they included the word of insolvency code. So you all know that this revival and reorganization company, this has been omitted after advent of insolvency bankruptcy code, introduction of insolvency bankruptcy code. Okay. So now coming to importantly 270. This is very important. So here only lot of changes have come. In fact, I have a PPT also for this. Time permits. I will run the PPT. Is it okay? Shall I take 10 minutes more, ma'am? Madam is not there.
You can take, sir.
Yeah, that's right. Because here, if you see a chart only, you can understand. That's also I prepared. Yes. So this is very important. See, what is Companies Act amendment to IBC, whatever is done in Schedule 11. Okay. So what is amended, we have to see. Okay. Well, because today, if you see, what I showed you is Companies Act. Yeah, 271. This 271, a company may, on petition under section 272, be owned by tribunal. If you see, earlier provision was that under section 433, I should say the earlier 433, it was giving under the ground, under what grounds the winding up petition can be filed. So after the government has proposed to come out with the new code, insolvency bankruptcy code, then they thought the code itself is to address the financial failure of the country, means of the corporate debtors. Okay, the code itself to contemplated to ensure that the corporate debtor, the financial failures of corporate debtors are addressed. So then, when there's a separate code is brought in, then why that provision has to be in the Companies Act? So what will happen? That then it will duplicate, because the same provision, same remedy, there will be two different remedy. One under the Companies Act, one under the Insolvency Bankruptcy Code. If the law is not amended under originally how it was in section 271 or 433 of 1956 Act, because that was included, that was carrying even winding up by creditor. But now, since there's a separate law to address financial failure, to initiate CARP and liquidation by creditor, so they want to separate it. So what happened? They made it amendment by virtue of Schedule 11. That only I was sharing in the PPT. So 233. This is the difference. I'll show you a difference, particularly. I'll share the PPT, you can see. So wherever it touch Companies Act, I made this as a PPT. Okay, I showed a BAR Act, no, so that's why I didn't show you this. Now already I explained in BAR Act by showing the BAR Act. This is the PPT of that provisions. So what are the provision I showed you? All that is there in the PPT. So you can literally go through the PPT. Reduction of capital, the charges which I explained to you. The word liquidator is included. Then resolution, which I explained to you, 117 is included. Winding up, 224. I told you that is included. The compromise 230, which I explained to you. So this is the difference between the IBC and what amendment is made in the Companies Act with respect to IBC. 230, 249, again, the language of insolvency code is introduced. This is fully omitted, which I showed you. The revival of sick companies are fully omitted. Okay, now coming to 270. Here the big important difference. Okay. Earlier the provisions of 270 was sounding, provisions of section 270 was winding up by tribunal voluntary. Okay. So it was saying it is fully substituted. Okay, it is fully substituted. And I'll show you how it is substituted. Down it is there. Okay, fully substituted. But the provision originally was that winding up by tribunal and voluntary. The new provision of 230, which enabled wind up company only by tribunal by bringing out scope of voluntary winding up outside the purview of Companies Act. That's why section 59 has been introduced under INB code. Okay. Now, this is the provision which I showed in the. Okay. Now, earlier if you see the winding up part 1, circumstances in which company may be wound up. The company, if the company is unable to pay debts, it can be wound up. Correct? But now, if you see section 231, okay, this is section 271. What I'm showing is section 271. But if you see section first A is if the company has by special resolution be wound up by the tribunal. But if you see the PPT, see here, what was the original position earlier? The company is unable to pay debts. Now what happened? For unable to pay debts, now there is a provision under the Insolvency Bankruptcy Code. What are those provisions? What are those provisions? I'll show you that provision. You all know, no? Now, unable to pay debts, the recourse available would be Section 7 by financial creditor, Section 9 by operations creditor, Section 9 by CD. So, this is the alternative. But by bringing section, by virtue of bringing sections on the Insolvency Bankruptcy Code 7, 9, 10, here the amendment made under the Companies Act, removing class A if the company is unable to pay debt. Now you come under IBC, because first revival has to be done, then only liquidation should be done. You don't jump into liquidation directly. That's the purpose of the code. Purpose of the code is to revive, not jumping into liquidation. Earlier it was permitted to jump directly into liquidation. So I myself handled a lot of 433 under 1956 Act for winding up a company. When there is a default, we directly issue notice and file winding up petition under 433 of 1956 Act. Even 213 also were, before amendment was that way. But after this introduction of Insolvency Bankruptcy Code, this provision is lifted. And instead of this 3 different section 7, 9, 10 is introduced. Now, how it stands today? Now it stands today. Companies Act. Now it stands today. If the company has by special resolution resolved that the company be owned up by the company. So only these scenarios, the company can be wound up by tribunal, not on default. Default comes under IBC. So now completely they carved out. They carved out completely the ground for initiating winding up by creditor for default is not coming within the section 271, but comes only under the Insolvency Bankruptcy Code. So the only in these circumstances now the tribunal may wound up. What is the circumstances? Company by special resolve that company be wound up. If the company has acted against interest of sovereignty and integrity, on application made by registrar, the tribunal of opinion affairs has not been conducted. This is out of investigation. No, when investigation is done, then they make out fraudulent manner the company is, then they can file even directly winding up. So it enables them to file winding up. Okay. If the company has made default in filing, then also for immediately preceding 5 years, then also there's a ground. So here there is no default question comes to trigger winding up. So this is the changes here. So that's why I plugged it out separately. Circumstances specified under class A. Class A in which company may be wound up under 2021 was removed. So 27 class A, see, class A and class D is removed. Now what happened? Class D is of this. All any other above together, that is removed. Class D is that. Earlier class D. Okay. Now 272 sounds. Now this 272 sounds now this way. This is after amendment. Okay. So these are the changes literally brought in, actually effective changes brought in by in the Companies Act after introduction of the INB code by the government. In fact, actually speaking, they literally worked only in the winding up provision only more. Rather, that means their whole mindset is on the winding up and bringing the scope of creditors winding up outside the scope of the Companies Act and put it under the Insolvency Bankruptcy Code in the form of 7, 9, 10. First revive, then go into the liquidation. So their entire focus is on that. Accordingly, they worked also, they brought the law also, code also, they brought the amendment also in the Companies Act by virtue of by bringing the Schedule 11 of the Insolvency Bankruptcy Code and given into effect immediately after introduction of the Insolvency Code. But what they literally not taken step is that to synchronize Companies Act and Insolvency Code for CARP and for scheme. For both, it is missing. Lot more amendment is required. So any doubt you can ask me. I done with my presentation. So whatever I understood from the law, I told. If you have something to offer, you can tell me. Any doubt? Yes. Okay. Any doubt? So far, what we deliberated? Ma'am, if there's no doubt, can we close the session? Because there's a lunch break, the next session also there.
Yes, sir. If there are no questions, then we can conclude with this session.
Thank you, Dhanapal sir.
Thank you very much, sir, for
Thank-
taking such a nice session. The session was very wonderful. Sir, I request you to kindly share the PPT of the session.
Sure, ma'am. I'll share.
And participants, now there is lunch break till 2 p.m. Next session will start at 2.
Thanks a lot for your patient hearing. See you all. Bye.
Good afternoon, everyone. Am I audible?
Yes, you are audible.
Good afternoon.
Yes, sir. Shall we start?
Yes, we can start.
Okay, sir. Good afternoon, everyone. Now the session will be taken by Rajendran sir on the topic Section 7 and Section 9 applications. Let me briefly introduce Rajendran sir. Sir is CS, cost accountant and IT. He is having over 25 years of experience in accounting, finance, taxation, corporate legal affairs, insolvency, restructuring and valuation matters. Sir is also having experience in managing complex insolvency proceedings under IBC, leading corporate restructuring, liquidation and resolution plans. Sir has managed multiple insolvency and restructuring assignments across banking, manufacturing and service sectors. He has represented matters before NCLT and CLAT, handled legal documentation and coordinated with COC, creditors and valuers, implemented governance frameworks and risk mitigation strategies aligned with regulatory norms. Now I request Sir to start with his session on the topic Section 7 versus Section 9 applications involving jurisprudence under IBC.
Thanks, Anjali. Thanks. Good afternoon, everyone.
Good afternoon.
Welcome to today's workshop on Section 7 versus Section 9. Applications evolving jurisprudence. As an insolvency professional, we frequently deal with application under Section 7 and 9 of IBC code. While both provisions enable creditors to initiate the CIRP, they cater to distinct types of creditor. Under Section 7, we have to deal with financial creditor applications. Section 9, we have to deal with operational creditors application. And involve different procedural and legal considerations. Understanding these differences is critical to ensuring compliances, effective representation, and strategic decision making during insolvency proceedings. Before starting PPT, we need to understand background and legislative context. Before the IBC, the recovery of dues, whether by financial institutions, banks, or operational creditors, was governed by multiple statutes like Companies Act, RDB, FI Act, commercial laws, which often lead to inconsistent results and dispute over priority of claims. Financial creditors with secured claim often clashed with operational creditors, including suppliers, employees, and government departments, over right to assets and recoveries. The IBC was enacted to provide a single, time-bound, and coherent framework for insolvency resolution process, promoting the revival of corporate debtor while balancing creditors' interests. Section 7 and Section 9 serve as the entry points for creditors to initiate CRP, but they differ significantly in scope, documentation requirement, and procedural safeguards. Actually, Section 7, financial creditors. Section 7 allows financial creditors, typically banks, financial institutions, or lenders, to file an application with corporate debtor has defaulted on a financial debt. Financial creditor usually have formal agreements and in many cases secured interest over the debtor's assets. Once a Section 7 application is admitted, the resolution process is largely controlled by the Committee of Creditors, where financial creditor hold the decision-making authority. There are judicial interventions have clarified the condition of default, admissibility, and the extent to which operational disputes may delay or prevent admission. Section 9 applications, operational creditor empowers operational creditor supplier of goods and services. Before filing an operational creditor, must issue demand notice under Section 8. Unlike financial creditor, operational creditor don't automatically form part of the COC. Thus, their participation in COC meeting is subject to a threshold of 10% of debt, as per Section 24(3)(c). Practically challenges which we face as a insolvency professional determine the nature of debt, whether financial or operational, is critical to deciding which section to invoke. For example, when we are we don't have earlier clarity कि home buyers will be treated under financial guide or operational guide. Managing pre-existing disputes and claims verification that could affect admissibility under section 7 or 9. Handling situations where government use interest interact with the operational guiders. So these are the things practically which we have to face. There are common pitfalls: misclassification of debt, treatment of operational debt as a financial debt under section 7, incomplete documentation, ignoring threshold limits, timing errors, because there is a limitation act 1961 and section 18 and 19, we have to submit the application within 3 years. So there are so many judgments are there which we will discuss in detail, because when we don't have clarity on specific section, or there is a little bit confusion, or there is any dispute, so then stakeholder directly approach to the adjudicating authority, then or otherwise COC or other stakeholders have to take means a decision in the light of the judicial judgments. So there are so many landmark judgments. For example, Swiss Ribbon versus Union of India, Committee of Creditors of Isar Steel versus Tish Gupta, recent section 9 Jurisprudence Court have refined the interpretation of default demand notice and the scope of operational guider. Objective of today's session is understanding the legislative intent, practical nuisance beyond section 7 and 9, explore the challenge faced by insolvency professionals. By the end of this workshop, participants will have a comprehensive understanding of both provisions enabling informed decision and professional excellence in insolvency proceedings. Let's start. Workshop on the topic section 7 versus section 9, applications involving jurisprudence under IBC. First, we will discuss preamble and evaluation of the IBC. The IBC code represents one of the most significant economic and legal reforms undertaken in independent India. It was enacted with the vision of the creating a consolidated, time-bound and character-driven insolvency resolution framework. Earlier, what was happening? The control was in debtors. After enacting the IBC code, now control is in the hand of the creditors. That would address the chronic problem of non-performing assets and promote credit discipline in the economy. Before the enactment, the IBC landscape was fragmented and inefficient, governed by multiple legislation such as SICA, recovery of debts due to bank and financial institutions, SURFACE Act, and various provisions under the Companies Act 2013. The result was delay, multiplicity of proceedings, and erosion of assets value, which were adversely affected lenders, investors, and the economy. Because all the earlier act was time bounded. IBC is time bounded when any application is accepted by the adjudicating authority under section 7, under section 9, under section 10. So as an insolvency professional, we have to complete the process within 180 days. There is a sanction period also there, 30 days plus 30 days. But within 360 days, we have to complete the insolvency professional with the extended period. But earlier act there was no provision to complete the resolution process. Though there was no time bound period. So when it will take very much time, so then what will happen? Then the maximization of value of the assets will be erosion. In this act, the objective is to maximize the value of assets and survival of the business. When any application is admitted by the adjudicating authority, when CRP process start, the object of insolvency professional as per IBC code to survive the business. If survival of the business is not possible and CRP fails, then company will go into the liquidation. So then objective will be different. Then objective will be to close the business and to sell the assets and distribute the proceeding under section as per section 53 waterfall mechanism. Means in both there are two steps. Number first, CRP. Number 2, liquidation. If liquidation fail, then company will go into the liquidation. When application is submitted as per IBC Act, sections 7, 9 and 10. Section 10 is for corporate debtors. When application section under section 9 is admitted by the adjudicating authority, so it's mandatory to issue demand notice under section 8 at least before 10 days. And there is also there is a provision, if there is a pre-existing dispute is there, so then application will not be accepted by the adjudicating authority. For example, in case if the same matter is in arbitration, okay, and party is submitting the application under 9, okay, so then adjudicating authority will not accept the application, because if there is a pre-existing dispute is there, so then under section 9 application will not be accepted. And same manner, when application under section 7 is admitted by the adjudicating authority, there are two things. Number 1, financial debt is there, and default must be there. In case if there is no default, if only financial debt is there, so then section 7 will not trigger. Means it's mandatory. In case if there is a default, so then under section 7 application can be submitted by the financial creditor. Okay, now along with these things, we also need to take care more 2 things. Number 1, threshold limit. If threshold limit must be more than 1 crore. When this act was enacted, so earlier in operational creditor the limit was 1 lakh. Now this limit is also increased under section 9 for threshold limit is now 1 crore for financial creditor and operational creditor. Threshold limit must be more than 1 crore. If default, if we are to recover only 80 lakh, so then in that case we will not be able to submit the application. We will submit the application, then adjudicating authority will not entertain or accept the application. Okay, now one thing more we need to take care. We need to submit the application within a time frame period as per Limitation Act, and as per Limitation Act 1963 and as per IBC, we have to submit the application within 3 years of the default. If 3 years has been passed, so then adjudicating authority will not accept the application. And now again question comes when limitation period starts. Okay, so that is the separate issue. For example, if party acknowledging the debt and refusing the debt, okay, and making the part payment, so then our fresh limitation period will start from that point. That is the separate thing. But normally we will have to submit the application within a time bound frame period as per Limitation Act. Okay, so but before enacting IBC, the control was in the debtor's hand. Okay, and after enacting the IBC code, now the control is in the hand of the creditors. Okay, if any application is submitted and accepted by the adjudicating authority, so then IRP will form the COC, and all the financial creditor, most 18 financial creditors will be the part of the COC, and all the commercial wisdom decision will be taken by only the financial creditors, who will be the part of the COC. Operational creditor can also participate in the COC if the debt is more than 10%. They can only participate, but they don't have the voting right. Voting right have only with the financial creditors, and all the commercial wisdom decisions are taken by only the COC. Okay, as we know, resolution plan is approved by the COC, then resolution plan is approved by NCLT, and adjudicating authority will approve the resolution plan if resolution plan in compliance with the IBC code. Okay, if resolution plan will be approved by the adjudicating authority, then that resolution plan will be bind on the on all the stakeholders. Okay, now we will also discuss the relevant cases. There are so many related and relevant cases. Actually, cases helps us to take a proper decision in case if we don't have any specific provision, any specific rule and regulations. Okay, now I will give you one more example. As of now, we don't have specific rule, regulation, and provision related to group insolvency, professional cross-border insolvency means provisions. Okay, so now there is a case, as you know, there was a case of Videocon. So that was the case of the group insolvency case. Now question comes, when we don't have specific rule and regulation and provisions, so then how educating authority can take decision? Okay. In this matter, there is a rule 11 who gives the power to the educating authority in case there is no specific provision, but there is a related matter in the IBC. Educating authority have the power to deal with these matters. Means rule 11 give the authority and power to the educating authority to deal related matters under the IBC till the time the specific rule and regulation or provision will be amended or in the IBC code. Okay. So, and I'm telling you again ki when we don't have any specific provision or if we don't have clarity, so then what we do? We have to refer the related judgments so that we can take the proper and appropriate decision. Okay, but sometimes what is happening here? There is ambiguity in the judgments. So practically, we also face sometimes this type of challenge. See, as you know, there is a case very important and famous case, Rainbow and Provincial Nigam Limited. In both the cases, judgment was given by the Honorable Supreme Court. But in one of the case, Supreme Court accepted their claim against the secured creditors. In another case, judgment given IBC Code Section 238. IBC Code will override all the other act. Okay, as per IBC Code, when there is any contradiction with any other act or any other law, so then IBC Code will override all the other acts. Okay, but the judgment given by the Supreme Court in both the cases, okay, in one cases they accepted, means the claim will be against treated as at par as a secured creditor. Okay, but as per IBC Act, whenever there is another provision contradiction with IBC code as per section 238 says, IBC code will override the other act. Okay, so that's why I'm telling you practically sometimes we have to face these type of challenges when we are looking the judgments and we are referring the judgments. Sometimes if there is ambiguity in the decisions taken by the authority, so then this type of practical challenge and problems we have to face. Okay. Now, preamble and evaluation of the Insolvency and Bankruptcy Code. Now, recognizing the need for holistic and modern insolvency regime, the Government of India constituted Bankruptcy Law Reforms Committee under the chairmanship of Dr. T.K. Vishwanathan in 2014. The BLRC proposed a unified framework that emphasizes early detection of financial distress, prompt resolution, and maximization of value. Its recommendations culminated in the enactment of the IBC code, which came into the force 20th May 2016. What was the need? Okay. Just a moment. Okay. What was the need of consolidated insolvency law? Fragmented legal framework, Pre-IBC area, prior to IBC, different statutes deal with specific aspects of recovery and insolvency. SICA was there. Focused on revival of sick industrial companies, but resulted in long days and misuse. Okay. And one thing more, I will add one thing, very important thing. Means in earlier act, now, the priority was in case of government dues and statutory dues. The focus was to recovery, means to recovery, means of government dues. The priority was on the government as statutory dues, means was the first priority to in the case of recovery. Okay, now after enacting the IBC code, if there is a government and statutory dues are to recover by the government, so then priority is not a not come on the first point. It will come on the fifth point. So we will also discuss the section 53 waterfall mechanism. Okay. Focused on revival of sick industrial companies, but resulted in long delays and misuse. Means RDBBI effect allowed banks to recover dues through debt recovery tribunals, but was limited to financial institutions. There was a SURFACE Act was there, empowered secured creditors to take position of assets yet only for secured debts. Okay, so but means if secured debtors will recover their amount, then what will happen for unsecured debtors? What will happen with the employees? What will happen with the other unsecured creditors? So that provision was not means covering these things. Companies Act contained winding up provisions but lacked a restructuring mechanism. So this was the practical problem. The multiple forms led to conflicting decisions, overlapping jurisdictions, and prolonged litigation, often resulting in liquidation rather than revival. Okay, then if you are facing problem, then if you will resolve that issue earlier, so then it will be better for the company as well as for the economy as well as for the government, because if government will interested to revive the business, so then what will happen? If business will revive, so then all the stakeholders will be able to make money. Okay, and if government will first priority is to only recover the government dues and statutory dues, then what will happen? Then survival of the business practically will not be possible. Okay, if business will survive, government and statute dues will be easy for recovery for government, and also for long run and future they will also make make money or recover on continuously for government dues and statutory dues. And in earlier acts, absence of time bound resolution, recovery of restructuring process stretched for years, reducing assets value. India's average recovery rate was below 25%, and the World Bank's ease of doing business ranking 2015 placed India 136 in the resolving insolvency. Lack of creditors' confidence. The earlier system favored debtors, promoters, retail control even during default. Creditor had little recourse beyond enforcement of security, often leading to liquidation. There was an economic imperative. The accumulation of NPAs and financial stress in the banking system required an efficient mechanism, ensure credit discipline, and preserve asset value, balance stakeholder interests, enable a fresh start for general business. Thus, a unified insolvency framework was essential to promote financial stability and economic growth. The objective of the IBC. What was the objective of the IBC? The preamble to the IBC clearly sets out in its intent and guiding philosophy. This code seeks to consolidate and amend laws relating to the reorganization and insolvency resolution of the corporate persons, partnership firm, and individuals. Ensure, and that was the main point, ensure time-bound resolution to maximize the value of assets. Okay. And also, for in case of CRP, resolution professional have to appoint two registered valuer. Okay. Registered valuer will submit the means valuation report with the resolution professional. Resolution professional will go through that detail. If report is in compliance with the and covering all the means things, so then insolvency professional will share that report with COC, and COC member will also means go through that valuation report. Valuation report is submitted with COC so that they can take decision in the interest of the business, and also in the case of the resolution means plan. But when any valuation report is submitted with COC, so COC is it's not mandatory for COC member COC to take decision on the basis of the valuation report. COC member refer that report so that they can take the decision in the interest of the business, because all the financial wisdom decisions are taken by only the COC members. But it doesn't mean that valuation report is prepared and shared with the COC members, and COC members will have to take the decision only on the basis of the valuation report. They only refer the valuation report. And why valuation report is important? Question comes whether section 7, whether section 9. Okay, when application is submitted, resolution professional have to hire the registered valuer for 3 different classes. If these assets are there, SFA, plant and machinery, and land and building. If specific assets are not there, then he will not means appoint that means class of registered valuer. So means in this, if company is in the CRP process, so then the objective will also for registered valuer to maximize the value of the assets, so that if resolution application is submitted, resolution plan is submitted by the resolution applicants, if COC members don't know the exactly value of the business, value of the assets, okay, so then there are very much chance they can take the wrong decision. Because if I know the value of the business is means 1000 crore, okay, if resolution plan is coming more than 1000 crore or around 1000 crore, so then COC member can take the correct decision, because they know the exact value of the value of the business. If they don't know the business, if resolution plan is submitted only for 700 crore and actual value of the business entity is more than 1000 crore, in the absence of the valuation report, they may take the incorrect decision. Okay, so that decision will not be in the interest of the organization. Okay, because in CRP process, the objective is to find out the resolution in the time bound period, and within time bound period, along with maximization of the value of the asset, so that revival of the business is possible. Okay, although if all these steps are taken, if revival of the business is not practically possible, then company will have to go to the liquidation process. Then liquidator will be appointed, okay, for the liquidation purpose. If resolution professional is continued, then he will be worked as a liquidator. Now, if liquidation starts, so then again a liquidator will have to hire a registered valuer. In case he found that there is a major difference in these assets value due to the timing gap, because in the liquidation, the objective of the liquidation or liquidator to sell the assets. Okay, in earlier, the objective was the approach was ongoing approach. Okay, in the liquidation, the approach will not be ongoing approach. In the liquidation, our approach will be to close the business. Okay, to sell the assets. After selling the assets, all recovery of the proceedings will be distributed to all the stakeholders as per section 53 waterfall mechanism. There is a standard priority are there. We are to distribute the sale proceeds as per the waterfall mechanism as per section 53. So this is the process under the IBC code, whether section 7 applies or whether section 9 applies. Okay, so in later slides we will also discuss related judgments in detail. Now coming to here, ensure time-bound resolution to maximize the value of assets, promote entrepreneurship and availability of credit, balance the interests of all the stakeholders, debtors, employees, government authorities. Okay, so that is also the objective, because if in case of CRP, so then maximization of value, so then all the stakeholders will be benefited, because they will also in position to get their dues. If they have already submitted their claims, whether claims are submitted by creditors, employees, government dues and authorities. One thing more. Now question comes. Government dues and statutory dues will be the part of the financial guide will be treated as a financial guide or operational guide. Okay. Government dues and statutory dues will be treated and covered under the operational guide. Okay, and will not be treated as a secured guide. They don't have the first priority. Okay. As per section 53 waterfall mechanism, they have the fifth priority. We will discuss in a further slide. But they will not be treated as a secured guider, number one. Number two, government dues and statutory dues will be covered under operational guider. Okay. Now, coming to the establish an insolvency bankruptcy board to regulate professionals and ensure transparency. In short, the IBC aimed to shift the focus from debtors in position. Okay. Earlier act, when any company was going in the in the revival for in liquidation, so the control was in the hand of the debtors. Okay. Now after enacting the IBC, the paradigm shift. Now control will be in the hand of the debtors. So it's called aim to shift the focus from debtors in position to creditor in control. Okay, and in creditor in control means there are two types of creditors: financial creditor and operational creditor. Okay, so that's why we are discussing section 7 and section 9. Okay, and section 10 says if any application is submitted by the corporate debtor itself for CRP process, so then application is submitted by the corporate debtor under section 10. Now, role of financial and operational creditor in the insolvency ecosystem. Introduction of creditors classification. A distinctive feature of the IBC is the classification of creditors into financial and operational creditor, each with the distinct rights and responsibility under the code. Because we must first need to clear whether the applicant is financial creditor or operational creditor, because the role and responsibility, the process, everything is different. Because if financial creditor will submit the application, then what will happen? He will submit the loan agreement, default, okay, and if any certificate from IU, so these type of documents will be enclosed with the application. In case of if when application is submitted by the operational writer, so then what will happen in that case? If there is agreement with corporate debtor and with the vendor, okay, if purchase order issued by the corporate to the vendor, okay, if invoice is there, if default as per agreement or as per purchase order. So these type of documents will be submitted or enclosed with the application. Okay. And also, Miss, in earlier stage, there was not so much clarity whether home buyers can submit the application under IBC or not. Number one. Number two, there was not so much clarity if they can submit the application to this. They should use the section 7 or section 9. Okay. So earlier there was a confusion. Okay. So now notification issued by the IBC code means IBC under the IBC code. So now home buyers can submit the application under the as a financial guarantee under this section 7. So means we need to clearly know whether applicant is financial guarantor or operational guarantor. Now the classification determines the manner in which insolvency proceedings are initiated, admitted, and resolved. Because if application submitted under 9, so then the provision is little bit different, because in that case we have to issue demand notice under section 8 at least before 10 days submitting the application under section 9. Unless until 10 days will pass, so then we as per act we cannot submit the application under section 9. Okay. And also we have already discussed there must not be any pre-existing dispute when we are going to submit the application under section 9. Okay, so this is the main thing. And also when we are talking about the section 7 financial character section 7, so then we also need to remember financial debt must be there, but financial debt itself will not trigger the section 7 unless until if default is there, unless until default is there. Okay. Financial character section 5758 what says typically include banks, NBFCs, bondholders, and other lenders who have disbursed funds against the time value of money. They play a key role in the corporate insolvency resolution process, especially through their control of the committee of creditors. They can initiate insolvency proceedings under section 7 upon the occurrence of a default of 1 crore or more. Okay, so this thing we have already discussed. Default financial debt, number 1. And default, number 2. Number 3, threshold limit must be 1 crore or more. Number 4, we also need to take care time period. Okay, if application is time barred, in that case also adjudicating authority can reject the application. Okay. The adjudicating authority NCLT has a limited discretion. Once default is established, the application must ordinarily be admitted as in the leading judgment Innovative Industries Limited versus ICICI Bank 2017. Means in this judgment, it was clearly mentioned if financial debt and default
Sir,
and
your slides are not moving.
pardon.
They are not moving.
Hmm?
Sir, your PPT is not moving.
No, PPT will move now, then I will go to another topic.
Your first page is only visible.
Okay. I will
Change
again.
Rama.
Okay. Sorry. Now it's moving. Now it's moving.
Not yet.
No, sir.
Just give me 1 minute. Now is this visible to everyone and moving? Please confirm. Now it's moving. Can you please confirm?
Yeah, we can see preamble and evolution. So that
And here, see, it's moving or not moving? Your first page coming.
sir, you'll have to change the page to understand that.
No, actually I want to know whether it's moving or not moving. Not moving. Now it's moving. The classification determines the manner it's showing. Okay. Okay. The role of financial and operational character in the insolvency ecosystem. Introduction of creditors classification. A distinct feature of the IBC is the classification of creditor into financial and operational creditors, each with distinct right and responsibility under the code. The classification determines the manner in which insolvency proceedings are initiated, admitted, and resolved. Financial creditors, as per section 5.7, 5.8, typically include bank, NBFC, bondholders, and other lenders who have disbursed funds against the time value of money. Just take 1 minute. Okay. Okay. Typically include banks, NBFC, bondholders, and other lenders who have disbursed funds against the time value of money. They play a key role in the corporate insolvency resolution process. They play a key role in the corporate insolvency resolution process, especially through their control in the committee of creditors. They can initiate insolvency under section 7 upon the occurrence of a default of 1 crore or more. The adjudicating authority has a limited discretion. Once default is established, the application must ordinarily be admitted. The leading case judgment is there. Innovative Industries Limited versus ICICI Bank 2017. Now, operational creditor, as per section 520, 521, include supplier of goods or services, employees, or other trade creditors, including government dues and statutory dues, are also part of the operational credit application. Their relationship with corporate debtor arise from commercial transaction, not lending. Okay. They can initiate insolvency under Section 9, but only after serving a demand notice under Section 8 and ensuring there is no pre-existing dispute. For that purpose, we can refer the leading case between Mobilux Innovations Private Limited versus Curispa Software Private Limited. Okay. They have limited voting right in the COC, ensuring balance but prevailing misuse of insolvency as a recovery tool. Means if any corporate operational creditor have their claim more than 10% of the total debt, so then that operational creditor can means participate the COC meeting, but they will not have the voting right. Okay, the voting right is only for financial creditors. Just give me 1 minute. 1 minute. Okay, now they have limited voting rights in COC, ensuring balance but prevailing misuse of insolvency as a recovery tool. Balancing of interest. IBC also ensures a level playing field for both class of creditors. Means it should not happen that financial creditors are only the part of the COC. So they will take decision only in the interest of the financial creditor. Okay, it cannot happen. Okay, and all the creditors will at least get their claim amount as an equivalent to the liquidation value. Operational creditors are protected by mandatory minimum payouts under the Section 32B. The division reflects the economic substance of transaction and aligns with global best practices. That is UK Insolvency Act, USA Chapter 11. Evolutionary significance. The jurisprudence around Section 7 and 9 continues to evolve, defining definitions of financial debt and operational debt. Number 1, treatment of hybrid instruments, procedural safeguards against misuse, balance between creditors' empowerment and debtor protection. Okay. Conclusion of this segment, the IBC 2016 has transformed India's insolvency landscape by creating a structured, credit-driven, and transparent mechanism for resolution. The distinct between Section 7 and Section 9 is foundational to this system, influencing who can trigger insolvency, how these disputes are assessed, and how control shifts during CIRP. Okay, we will discuss the key definitions. Okay, but now we will discuss the key definitions because it's very important. First, exactly which is covered or which is not covered, and what is defined for financial character or operational character as per IBC code, so that as an insolvency professional we can take decisions and work as per the IBC code. Section 5, key definitions under the insolvency and bankruptcy code. Importance of definitions under Section 5. The definition of Section 5 of the IBC code form the foundation of the insolvency framework as they determine who can initiate insolvency proceedings, what type of debt qualifies under Section 7 or 9. Okay, when default occurs for the purpose of triggering the CIRP, the classification and interpretation of financial debt, operational debt, and default directly impact the maintainability of and outcome of insolvency applications. As we have discussed, means for financial debt, okay, is there. So then first we need to define whether it's a financial debt or operational debt. So then we need to check if there is a default, Okay, and in case of default, so then we need to see the threshold limit is as per this code or not. Also need to see whether application is not a time barred. Over time, the judiciary has elaborated on these definitions to bring clarity, commercial realism, and fairness to the IBC process. Key statute definitions. Section 5.8 Financial debt. As per Section 5.8 defines financial debt as a debt along with interest, if any, which is disbursed against the consideration for the time value of money and includes followed by an inclusive list of subclauses A to 1 essential ingredients for the purpose of financial debt. To qualify it as a financial debt, 3 conditions must be satisfied. There must be a debt, liability or obligation in respect of claim which is due. The debt must have been disbursed. Money has actually been given or released. Okay. The disbursement must be against consideration for the time value of money. The creditors expect compensation over time, typically interest of return. Because if bank is giving, a financial institution is giving money to the company, means if money is giving, that means they are giving the loan to the company. Okay, if loan is given and loan is given, why loan will given? They will expect the rate of return. Without rate of return, so they will not, neither bank will give, neither financial institution will give the money to the company, because when they are giving money, so they expect the rate of interest rate of return as per agreement. Okay, because when that company or that entity will use that money, they will also make money using that loan. Okay, so that's why as a in the form of compensation, corporate debtor has to give a rate of return for using the loan as per the loan agreement. Okay. Now, illustrative example under Section 5.8, money borrowed against payment of interest, amount raised through debenture, bonds or notes, acceptance of credit facilities, lease or hire purchase transactions, any counter indemnity obligation in respect of a guarantee, any other transaction having the commercial effect of a borrowing. So these are the illustrative example which covers under Section 5.8 for the purpose of financial debt. Now, there are judicial interpretations and key cases laws related to the financial debt and operational debt. Judicial. Now, Innovative Industries Limited versus ICC Bank. The judgment given by the Honorable Supreme Court established that for Section 7, the existence of financial debt and default are objective facts. Once default is proved, NCLT has no discretion but to admit the case. So that is the landmark case in the IBC code. Means as per clear cut judgment given by the Supreme Court, if the existence of financial debt is there and default are objective facts, and once default is proved, then LCLT will have to accept the application. They don't have any discretion. They cannot reject the application unless when financial debt was there and default was also there. So then in that case, NCLT will have to accept this application as per the IBC code, and NCLT has no discretion but to admit the case. Okay, so that was a leading case and judicial interpretation, I mean referring to the Section 7. Now there was another landmark case between Pioneer Urban Land and Infrastructure Limited versus Union of India. In the same case, in this case, judgment given by the Honorable Supreme Court held that home buyers who pay advance to real estate developers are financial creditors. Since such payments are made against the time value of money, expanded interpretation beyond traditional lending. So means, as per this judgment, Supreme Court clearly defined or clearly mentioned home buyer's application will be covered under Section 7 and home buyers will be treated as a financial creditor because these payments are also made against the time value of money. Okay. Now, there was another case, leading case, Phoenix ARC Private Limited versus Spade Financial Services Limited 2021. That judgment and judicial interpretation was also given by the Honorable Supreme Court in this case clarified that the intent of transaction determines whether it is a financial debt. Shame or collusive transactions don't qualify. Distinction drawn between genuine disbursement or investment for control. There are another landmark cases. Arun Jain, interim resolution professional for JP Infratech Limited versus Axis Bank Limited, determined that mortgage guarantee or third party security don't automatically make the security provider a financial guarantor. Okay. So there must be a disbursement to the corporate debtor. Okay. In this case, what is happening? Determine that mortgage guarantee or third party security don't automatically make the security provider as a financial guarantor. There must be a disbursement to the corporate debtor. Now there was another case pertaining or related to the Section 7 leading case, Lakshmi Pat Surana versus Union Bank of India 2021 year. Judgment was given by the Honorable Supreme Court, held that a corporate guarantor of a loan is also liable under Section 7 if the principal borrower defaults. The guarantee is also a financial debt. So that is also a very, very important point here, because now I have also submitted 2 or 3 or 4 applications. Then if any guarantee is given by another company, if the main borrower is not giving paying the money, so then guarantor will have to pay the money. Okay, so then the application by bank or financial creditor can maybe or will be submitted against the guarantor, and then guarantor will have to pay the money in case if financial creditor is unable to recover from the principal borrower. Okay, so then after this then guarantor can also recover the same amount from the principal borrower. But when any guarantee is given by any company or any entity on behalf of other principal borrower, so then financial creditor can submit the application against the corporate guarantor. Okay, if financial creditor is unable to recover from the principal borrower, so then in case of default, financial creditor have the right to submit the application against the corporate guarantor. Okay, so means in pertaining to Section 7, there are 2 or 3 things are very important. Number 1, if financial debt is there, default is there, so then NCLT have no right to discredit but to admit the case. Number 1, that was an important judgment. Number 1. Number 2, home buyers will be covered under Section 7 and treated as a financial guarantor. Number 2, that was also very important from application point of view. Number 3, in case of corporate guarantor, okay, if corporate guarantor is there, so then financial creditor can also submit the application against corporate guarantor in case financial creditor is unable to recover their amount from the principal borrower. So that is also a very important point here in reference to this leading judgment. Now coming to the operational debt. Operational debt is covered under section 521. Section 521 defines operational debt as a claim in respect of the provision of goods or services, including employment, or a debt in respect of the payment of dues arising under any law for the time being in force payable to the central government and state government or any local authority. Means here operational debt is covering here payment or provision for goods or services, number one. Number two, it will also include here means payment for means for services. See here, this is also claim in respect of provision of goods and services. If any material is being supplied by any vendor, so then in case of default, so then that is operational debt, and then operational creditor can submit the application against the corporate debtor. Okay, in this operational debt, provision for goods and services, including employment, okay, and also including dues to the central government or state government or any local authority. Okay, means operation for operational debt, we are covering in case if material or any services is provided by any vendor or any supplier, so that entity or that association or that person will be covered under operational debt. Number two, in case of misemployment, okay, if any employee, if employee related debt is there, also will be the part of the operational debt. Number three, most important, all the central government, state government or local authority dues will be covered as operational debt. This is a very means important, because if we have clarity if what will be covered in the operational debt and financial debt, then accordingly we have to submit the application with the authority. Okay, and the beauty of this code is this key, this code is providing, this is a time bound period process in CRP, maximization valuation of the asset is there. Okay, the plus point is this, if we have the all the standard means process and formats are there. For example, if claim is to be submitted by the vendor or supplier, the specific form is there. If claim is to submit by the employee, specific format is there. If claim is to submit by the central government, state government, then specific format is there. Okay, so means we have a specific formats are there, which also help us for smooth means process of the CRP process. So that is the plus point. Means if you see another act, you may not find the specific formats are there. For example, if I am to give the public announcement, actually we have the specific format. Okay, if I am to submit the application, okay, so it's clearly mentioned that is the form for a financial character, for operational character, for corporate data. Okay, so means each and everything is well defined in the IBC code for whether as per section 7 for financial character, for operational character, and for corporate data. And all the further documents and formats are specifically already defined in the proper formats. Okay, that really helps. Okay, because if we don't have this specific formats and so then sometimes it may take much time, because as we have to complete the insolvency process within 180 days. Okay, if I'm not getting the data, means claims in the specific formats, if characters are giving means incomplete information in their claims, and government is also giving incomplete information. So then it will take much time. So then, as a resolution professional, we will not be able to complete the resolution process in time. So that will be means very awkward situation for us. Okay, so that's why. So that's why. Okay, now what are the essential ingredients? There must be a claim, a right to payment, whether disputed or undisputed. It must arise in respect of supply of goods or services, employment dues, statute dues payable to government authorities. The obligation should be directly connected to the operational functioning of the corporate debtor. Okay, so these are the essential ingredients for the purpose of operational debt. A right to payment, whether disputed or undisputed. Okay. Now we will understand in the light of the leading judgments. Okay. Judicial interpretation and key case laws. The leading case in reference to the section 9, the Mobilex Innovations Private Limited versus Crusa Software Private Limited 2018. In this Honorable Supreme Court given judgment, that judgment is landmark judgment, because when we have to refer the specific rule and regulations, then we have to refer the leading judgments given by the adjudicating authorities. So these judgments really provide the base, okay, so that we can take the appropriate decision, okay, in the light of the judgments, okay, in case of any clarity. So now that was also a very landmark case, but pertaining to the section 9. Landmark case defining operational debt and pre-existing dispute. Okay, for the purpose of section 9, there must be a operational debt, there must be a default, there must not be pre-existing dispute. So that is the mandatory requirement for the purpose of submitting the application under section 9. Held that the insolvency cannot be used as a substitute for recovery where genuine disputes exist. Okay, operational debt must arise out of debt provision of goods and services. I have already given you example. In case there was operational debt, there was a default. Okay, threshold limit was also equal to or more than 1 crore. Okay, but as per agreement, okay, the same issue or concern was being handling as per the arbitration act, as per the arbitrator, by the arbitrators, as per the agreement. So that means, in case if this thing is in the process, so then party can approach to the adjudicating authority and says this case is in this case pre-existing dispute is there. So in that case, adjudicating authority will not accept the application, because clearly mentioned in this leading judgment, held that insolvency cannot be used as a substitute for recovery where genuine dispute exists. Okay, means when dispute is already there, pre-existing dispute is there, in that case you cannot approach to the adjudicating authority to submit the application. Okay, means it's mandatory for the section 9. There must not be pre-existing dispute. So that was the leading case or judgment pertaining to the section 9. As a insolvency professional, so many times we refer these type of landmark cases and judgments. There was another case between K. Kishan versus Vijay Nirman Company Private Limited 2018. In this also, Supreme Court given the judgment, arbitration proceeding pending before filing a Section 9 application constitute a pre-existing dispute. Okay. Reinforce that IBC is not a substitute for contractual dispute resolution. Okay. We are already discussed this thing. If pre-existing dispute is there, means arbitration proceeding is already in the process. So that means pre-existing dispute is there. That was the means contractual dispute resolution. Okay, so then it cannot reinforce the IBC is not a substitute for contractual dispute resolution. Okay, so these are the means leading cases and judgments, and also very useful in practical life. As an insolvency professional, we have to deal many times in case we have a clarity means and know the related means cases and judgments. So in that case we can easily take means decision. Okay, there was another landmark case, Colonel Vinod Avasthi versus AMR Infrastructure Limited, NCLT. That case was means judgment was given by the Honorable NCLT in 2017, held that LOTs, public home buyers, were not operational guider. Okay, before the amendment. Okay, their payment did not relate to the supply of goods or services, but investment, later changed by the 2018 amendment, recognizing them as a financial guider. Okay, so means if we are to refer the case for the home buyers, okay, if any adjudicating authority, when we are submitting any application, if we know there is a already judgment is there and given by the adjudicating authority, we can refer. Okay, so for knowledge purpose also, it's very means necessary and important when we are dealing means section 7 and 9 means in this judgment clearly mentioned home buyers will be treated as a financial guarantor, not a operational guarantor. Okay, so that means judgment is also a very means critical and important. Okay, from home buyers means application point of view. Okay, Rashtriya Ispat Nigam Limited versus Diwan Chand Ram Saran. Okay, in this case, judgment given in 2017 by the Honorable Enclave confirmed that transportation, manpower supply, and maintenance services qualified as operational debt. Okay, means if earlier means the content or matter, we were in the impression that in operational debt will cover who supplied the goods and services, including employment and government dues and statute dues. Okay, but this services provider company, okay, example, transportation company, manpower supply company, and maintenance services company qualify as a operational debt. Okay, so that is also very important. For example, if my client comes, okay, and they supplied the they were providing the manpower supply. Okay, if I know this is covered in the IBC code in the operational debt, so then I can suggest and I can go for to submit the application under section 9. Okay, unless until I don't know which activities are covered under the financial debt and operational debt, so then it's very difficult for me to take a decision as an insolvency professional. Okay, so that's why it's very critical, crucial, and important. First, we must know what type of activities are covered under financial debt and operational debt, so that accordingly we can take appropriate decision and also give advice. Okay, in the absence of the clarity, we will not be able to take means correct decision. Okay, and if we know and we have clarity, so then we can file the application accordingly, because the format, the procedure are little bit different, because in case of financial debt we have to provide certain documents, in case of operational guider we have to provide certain documents. Okay, so that's why it's a very means important. First we know to know whether it's operational debt or financial debt. Okay, and what type of activity is covering under operational debt and financial debt. There was another landmark judgment and case, Parziba Industries Limited versus Canara Bank. Okay, that case was pertaining to 2021, and the judgment given by the Honorable Anclate clarified that the contractual dues must be directly related to operations. Advances or deposit refunds may not always qualified as the operational debt. Statute dues as the operational debt. So in this judgment, clarified that the contractual dues must be directly related to the operations. Okay, means all the contractual dues must be related to the operations. Okay, if loan is given, so that is not the contractual means dues. Okay, related to the operations, that will be the financial. But if contractual dues must be directly related to operational activities, so that will be covered under the operational debt. Advances or deposit refunds may not always qualify as a operational debt, but statute dues as a operational debt. Statute dues payable to government authorities such as GST, tax, or PF are included in the operational debt. Okay, now Class Traders versus C&C Concession Limited, Anclate. Judgment given by the Honorable Anclate in 2021 upheld that the government departments are operational characters for dues arising from law. Okay. Okay, now we can also means define what are the government dues and what are the statute dues. We can also define when any payment is going to the consolidated fund of India. So then these are the government dues. Okay, when the payment is directly not going to the consolidated fund of the India, so and so these will be the statute dues. Okay, so these are the difference between the government dues and statute dues. Now, section 312 default. So that is also important. First, we need to know what are the financial debt, operational debt. So then we need to define if default is there or not. Section 312 defines default as non-payment of debt when whole okay. Non-payment of debt when whole or any part of installment or installment of the amount of debt has become due and payable and is not paid by the debtor or the corporate debtor, as the case may be. Okay, so means, for example, whether it's a financial debt or whether it's a operational debt. Now we are talking about the default. What will be the default? Default means if whole amount, if part amount, if installment, if any part payment which is due and not paid by the debtor or corporate debtor, so it will cover. I mean that will be that is defined as a default. What are the essence of default? Occurs when a debt becomes due and remains unpaid, irrespective of reason. Default may be in full or in part. Even one or rupee one of unpaid beyond threshold, okay, is sufficient. Okay, establishing default is central to admission of a section 7 and 9. Okay, means when threshold limit is crossing or equal, so then section 7 and 9 will trigger, may trigger. So then creditor will have the right to submit the application as per the IBC code. Okay. Now, the judicial interpretations and judgments related to default we will discuss. Innovative Industries Limited versus ICICI Bank in 2017, the judgment given by the Honorable Supreme Court defined default as an objective fact not dependent on dispute or intent. Okay, means default will be an objective fact. Okay, no dependent or dispute. Once default is shown through credible records, loan documents, bank statements, IU, the NCLT must admit the petition. Okay, if default is there, it doesn't matter if I have a financial debt and I didn't do any default, so then section 7 will not trigger. In the same case, if operational debt is there, if default is not there, so then section 9 will not trigger. Okay, so means default must be there, whether application 7, whether application 9. Okay, in both the cases, default must be there. If default is not there, and if default is there, okay, so then NCLT will admit the petition. Okay, so that is clearly mentioned in this judgment itself. Means in case of default, and default can be shown and in related documents can be produced and enclosed with the petition, loan document, okay, bank statement, means loan document the agreement between corporate debtor and creditors. Okay, bank statement ki when disbursement of the loan. Okay, IU, okay, certificate from IU means the loan is pending. Okay, and default happened at the end of the corporate debtor. So these type of the documents are submitted with the application under section 7. Okay, now there was another leading judgment between Transmission Corporation of Andhra Pradesh versus Equipment Conductor and Cables Limited in the year 2018. In this case also, Honorable Supreme Court given the judgment. In section 9, the existence of a default must be accompanied by absence of a pre-existing dispute. Okay, that is the mandatory requirement we have discussed in this case also. Means whenever section 7 will trigger, okay, application only will be accepted by the adjudicating authority in the absence of the pre-existing dispute. So that is clearly mentioned also in this judgment by the Honorable Supreme Court. Okay, now there was another case with Dhanapal Industries Power Limited versus Axis Bank Limited in the year 2022. Supreme Court introduced an element of judicial discretion for admitting section 7 applications. Even if default exists, NCLT may defer admission based on the equitable consideration pending regulatory receivables. Okay, so means that is also a judgment given by the Honorable Supreme Court. Even default exists, NCLT may defer admission based on the equitable consideration pending regulatory receivables. However, this decision remains controversial and narrowly applied. Okay, there was another case, Dena Bank versus C. Shivkumar Reddy in the year 2021. In this case also, judgment given by the Honorable Supreme Court clarified that acknowledgement of debt or recovery actions can extend limitation under Section 18 of the Limitation Act, reinforce that default may relate to an ongoing liability. Means in this case, that was a very important leading judgment and case, clarified that the acknowledgement of debt or recovery action, okay, can extend limitation under Section 18 of the Limitation Act. As we have already discussed, in case if there is acknowledgement, if for example, if party sends notice to the another party, that amount is pending for recovery. If another party is refusing, accepting, acknowledging, okay, and or means giving part payment, so then our recovery period will extend, and from that point of time, okay, so then limitation period will be extended from that point of time also. Otherwise, normally we have to submit the application within 3 years. In case if there is acknowledgement is there, part payment is there, so then our limitation period will extend from that point of time. So that was the very also important and useful judgment. That means in this case also clarified that the acknowledgement of debt or recovery action can extend limitations under section 18 of the Limitation Act. Okay, now there is a comparative summary table. Okay, we will understand nature. For financial debt is covered under section 5(8), operational debt 521, default under section 312. Nature, borrowing is given by the creditor, by bank, by financial institution. Objective is to get a rate of return on the loan amount. Here, dues from supply of goods and services or employment, including government dues and statute dues. Default means non-payment of due debt, that is the nature. Test, disbursable against time value of money, arise from operational activity. Debt dues are unpaid. Creditor type, here bank, NBFC, lender, bondholders. These are the covered financial under financial debt. Operational debt to be covered, supplier, vendor, employees, government dues. Okay. Default means common to both. Okay. Key cases, Innovation Industries 2017, Anuj Jain, in the for operational debt, Mobilix and K Kishan. That was the leading cases. Here, default Innovative Industries 2017 and Vidarbha 2022. Relevance, financial debt attracts section 7 application, operational debt attract section 9 applications, and default attract trigger even for both. Okay. So these are the practical implications in case. So we will discuss the key cases, and we can take, if you want to take break for 5 to 10 minutes, so we can take break. Do you need break for 10 minutes? Please confirm we want to take break for 10 minutes? Nobody is responding. What happened? Okay. We are taking break for 10 minutes. Okay.
Sure, sir.
Okay. Thank you.
Okay, let's start.
Yes, sir.
Now there are the practical implications. Misclassification of debt can lead to dismissal at the admission stage, because if we don't have clarity for a financial guide, if earlier we were not aware home loan buyer will covered under financial guide or operational guide. Now it's very clear after the notification issued by the IBBI. Home buyers will be treated as a financial guide. If we are submitting application under section 9 for home buyer, so means if there will be any misclassification of debt, then adjudicating authority will dismiss the petition. So it's very important and critical to classify first the debt as per the IBC code, and accordingly application must be submitted with the adjudicating authority. Number 2, financial debts require proof of disbursal and interest, whereas operational debt requires proof of supply and invoices. In case of financial debt, so what will happen? We need to submit the proof that we have given the loan. Okay. And by what period we have received the interest amount? By what period we have not received the interest amount? Means when we will submit the application with the adjudicating authority, we need to attach or enclose the proof for pending loan amount and pending interest amount as on that date, when on which date we are going to submit the application with the adjudicating authority, because in this case we are not only to recover the principal amount, we are also need to recover the interest amount also as per the means loan document or as per loan agreement. So that's why we need to attach or include the means pending principal amount along with the interest amount. And for that purpose, we can also we are also need to attach the certificate from IU. And operational debt requires only proof of supply and invoices. Okay, but also need to take care there must not be any pre-existing dispute in case of operational debt when we are submitting application under section 9 with adjudicating authority. And number 3, determining default date is crucial for limitation and threshold applicability. Okay, we earlier also discussed. First, we need to clearly define whether financial debt or operational debt. In second step, we need to check and verify default. Then we will need to check and verify threshold limit. Then we will check the limitation as on default date. That is mandatory unless until we are covering these points for the purpose of submitting the application. If default date is after the limitation period, so then in that case also adjudicating authority will dismiss the application. So that's why we need to take care these points very carefully before submitting the application, whether under section 7 or whether in section 9. In case if we need clarity, so we can also refer judicial interpretations. We can also refer the leading case judgments related to that concern. If we don't have clarity, so then we can also refer the leading cases in the absence of any section or provisions. For more clarity, we have to refer the leading cases. Understanding judicial interpretation helps insolvency professionals prepare robust applications with the right documentary evidence. So these are the practical implications we have to define, we have to take care when we are going to submit the application under the section 7 and section 9. Okay. Now, we will discuss the leading case and judgments in detail. Earlier, we discussed in reference to the section 7 and section 9, and also for financial debt and operational debt and default. In reference to these means definitions and sections, we refer the leading cases and judgments in shortcut or in summary, but we will discuss the leading cases for better understanding. The key jurisprudential evaluation, key case laws, Innovative Industries Limited versus ICICI Bank and others in the year 2017, key case on section 7 applications, Innovative Industries Limited versus ICICI Bank and others 2017, citation 2018 1 SCC 407, Court, Supreme Court of India, Honorable Supreme Court of India, Bench, Justice R.F. Nariman and Justice Sanjay Kishan Paul. Date of judgment given on 31st August 2017. Reference and brief facts. Okay. What was the reference and what were the brief facts? Okay. The case holds the distinction of being the first judgment of the Supreme Court of India interpreting the IBC 2016. It laid down the foundation for the jurisprudence governing insolvency resolution and clarified the scope and application of section 7 of the code, which empowers a financial creditor to initiate the corporate insolvency resolution process upon a default. So that was the leading case and judgment given by the Honorable Supreme Court. Innovative Industries Limited. Again, not moving. Just give me 1 minute. Okay. Innovative Industries Limited has had availed credit facilities from a consortium of banks led by ICICI Bank. The company defaulted in repayment of its dues. Consequently, ICICI Bank, being a financial creditor, filed an application under Section 7. Okay, means Innovative Industries Limited took a loan from banks. Then, as a financial creditor, ICICI Bank submitted application under Section 7 before the NCLT, Mumbai, seeking initiation of the CIP against the company. However, Innovative Industries resisted the admission of the petition on the ground that it was protected by the MRU, Special Provision Act 1958. Okay. But as we know, when any contravention is there with other laws, then IBC Code 2016 Section 238 says IBC code will override other acts. Okay. So on the same means matter, Honorable Supreme Court took a decision. However, the Innovative Industries resisted the admission of the petition on ground that it was protected by under the Maharashtra Relief Undertaking Special Provision Act 1958 MRU. The state government of Maharashtra had issued a notification under the MRU Act declaring the company as a relief undertaking. and thereby suspending the company's obligation to pay its creditors temporarily. Okay, means MRU, the state government also issued notification. These means companies have a special status or relief undertaking and asking for suspending the obligation to pay the creditors for temporarily. The corporate debtor contended that the virtue of the notification, its liability stood suspended, and therefore no default could be said to the exist with the meaning of the section. Okay, that was the contention from the corporate debtor side. Okay, could be said to exist with the meaning of the section 312 of the IBC. It was argued that the IBC proceeding could not be initiated against a company enjoying state protection under a special law. Okay. If any company is having the special status from any state government rule or any authority, okay, so will not allowed to give a special means authority or any other special concession to that entity. When IBC is in the picture and banks and financial institutions are going to submit the application under section 7, if company is having any status, because IBC code clearly defined as per section 238, whenever IBC code act in case of any contradiction or any, so then in all these situations and always IBC will override the other act. Okay. We will also discuss in further cases. For example, I'm also giving you another example with this case. For example, if income tax authority is coming and asking if the assessment is pending and this claim is pending, so then if they are not submitting their claim within a time period, so then the claim will be rejected. No special concession will given to the government authority even also. For statutory dues, they are also bound to submit their claims within a time frame period, because otherwise CIRP is a time bound proceeding. Only 180 days are there. In case if any authority is taking time, okay, or taking for special concession, so then the objective of this code will be defeated. So that's why no special concession can be given in any circumstances to any company under any statute or any special protection from state law or any other law. So on that basis, judgment given by the Honorable Supreme Court. If default is there, debt is there, default is there, and all the other means compliance as per IBC code is okay, so then NCLT will not dismiss the case. NCLT will have to accept the case. Now, what was the issue before the court? Supreme Court was called upon to decide the following key issues. Whether the Maharashtra Reef Undertaking 1958 would override the experiment. The issue before the court was the Supreme Court was called upon to decide the following key issues: whether the MRU could override or suspend the operation of the IBC code 2016. That was the issue before the court. Whether the notification issued under the MRU Act could protect the company from being proceeded against the under section 7 of the IBC. What is the nature and scope of inquiry that adjudicating authority is required to make while admitting or rejecting a Section 7 application, particularly concerning the meaning of default. So these were the issues before the court. Okay. Gist of the verdict: the Supreme Court delivered a landmark and foundational ruling that clarified the supremacy, scope, and framework of the IBC Code. The court emphatically held that the IBC has an overriding effect over all other inconsistent laws in force by virtue of the Section 238 of the Code. Okay, means when IBC Code have the authority to override other act in case of if any inconsistency is there, by virtue of Section 238, IBC Code will override the other act. Okay, now the court had that the test for admission under Section 7 is straightforward and objective. Once the adjudicating authority is satisfied that a financial debt exists, a default in payment of such debt has occurred, the application is complete in all respect. The application is complete in all respect means as per the IBC Code. So then adjudicating authority must admit the application and commence the CRP. There is no scope for further inquiry into the reason for non-payment or the existence of any external protection under state legislation. Okay, so that was clearly mentioned in this leading case and judgment. If debt is there, default is there, and application is complete in all respect as per the IBC Code, so then no external or any special concession by any state authority or any other authority will be considered. Section 7 will trigger, and IBC have the supremacy, authority or power to override all other inconsistent law by virtue of Section 238. Okay, so that was the leading case, leading judgment. As a insolvency professional, we have to refer this case very much. Okay, so that was the leading case and judgment. Very important. Okay, means in case if any authority is coming and approaching the adjudicating authority, this application must be dismissed because this company have the special provision, special approval, special status as per any other law. So that will not be entertained by the adjudicating authority because IBC Code clearly mentions IBC Code will override all other inconsistent laws by the virtue of Section 238. Okay. Now, it was further held that the Maharashtra relief undertaking, being a state law, must give way to the IBC, which is a parliamentary legislation enacted by the concurrent list by virtue of the Section 238. The IBC has overriding effect in case of inconsistency with any other law, including state statutes. Therefore, the notification under the MRU Act could not be used to prevent or stay insolvency proceedings initiated under the IBC. Just in reference to valuation principles, although the case didn't directly deal with the valuation methodology or asset assessment, it has deep implications for valuation and valuation preservation principles under the IBC. The Supreme Court recognized that the IBC is a time-bound resolution mechanism designed to maximize the value of the corporate debtors' assets by preventing further deterioration due to delay or prolonged litigation. By clarifying that the trigger for insolvency is an objective default test, the court ensured that creditor could move swiftly to initiate resolution proceeding, allowing value to be preserved at the earliest stage. In other words, early admission under Section 7 prevents value erosion and facilitates continuity of business, enabling a more effective and accurate valuation during the resolution process. The case thus established the value preservation philosophy that underpins the IBC framework, that insolvency is not a punitive measure, but a process for timely revival and maximization of value of asset. Means when any company is going in the resolution process, okay, that is not a means punitive measures, means that the intention is not to penalize to the company organization. Okay, the objective of this code is to try to survive the business. Okay, and do the maximization of value of the assets. The intention is to survive the business. Actually, insolvency professional support and helps using their skills, experience, and support, try to revive the business. Although all the commercial wisdom decisions are taken by COC members, because resolution plan is approved by the COC members, resolution professional can review the resolution plan and ensure that resolution plan is means consistent with the IBC code and in compliance with the IBC code. Okay, if that resolution plan is in compliance with the section and all the provisions as per the IBC code, so then if resolution plan is accepted or approved by the COC members, so then if further resolution plan is also approved by the NCLT, NCLT will also see this resolution plan is means in compliance with the IBC code. If there is no inconsistency with the rule or law and regulations, so then NCLT will also approve that resolution plan, which will be binding upon all these stakeholders. Okay, so means objective and intention of this code is not a punitive. Okay, only to revive the business for the interest of all the stakeholders. Okay, now other principles propounded IBC as a complete code. The Supreme Court declared that the IBC is a comprehensive and self-contained, okay, legislation for protecting the existing insolvency framework. It aims to balance the interests of all stakeholders and provide a uniform mechanism for insolvency resolution. Definition of default is also defined by the Honorable Supreme Court in this landmark judgment. The court elaborated that default as defined under Section 312 means non-payment of debt when it has become due and payable. The NCLT is required to ascertain that this default objectively from records such as loan documents or information utilities. Missing this judgment clearly mentioned, elaborated the default also defined as per Section 312, non-payment of debt when it was due. So then it will covered, it will come in the preview of the defaults. Okay, so NCLT is required to ascertain that default is there. Okay, if default is there, so they can refer the loan documentation, okay, or documentation and reports from issued by the information utilities to ensure that financial debt was there, but also a default is there. Okay, so if default is there, so then adjudicating authority will accept the application. Now, limited role of the adjudicating authority. Because adjudicating authority, NCLT also has a limited role, because when financial creditor means proves financial debt along with default, along with threshold limit, along with limitation, means the application is not a time bar. So then adjudicating authority have a limited scope. Okay, means adjudicating authority will have to accept the application. Okay. The NCLT's role at the admission stage under Section 7 is summary and administrative in nature. It is confined to verifying the existence of debt and default. The NCLT does not have the discretion to consider the debtor's financial viability or external state protections. Okay, means NCLT will not consider ki debtor is in position can pay or not pay. Means they will not take decision. Okay, NCLT does not have the discretion to consider debtor's financial viability or external state protections while deciding admissions. If company is also having the any external state protections, although NCLT will have to admit the application. Okay, because adjudicating authority have the limited role as per the IBC code. If once application is submitted, so then proceeding will be start as per the IBC code. Okay, now coming to the overriding effect of section 2238. We are already discussed, and that is very important. The IBC shall have precedence over all other conflicting legislations. This ensures that the code operates as a uniform and supreme law in insolvency matters across India. Okay. We have already discussed, in case of any inconsistency in law, then IBC code always override all the other acts. Okay, that means IBC code section 238 have the overriding effect. That is very important. Also mentioned in this case itself. Now, objective and time-bound mechanism. The code also again reiterated that the IBC primary objective is timely resolution, and that adjudicating authority must decide admission or rejection of application within 14 days of filing as prescribed under section 7(4). As we know ki adjudicating authority have to admit or reject the petition within 14 days. Okay. Because IBC objective is to provide timely resolution. Because earlier act was not providing the timely resolution and it was taking time. Due to time taking, there was a deterioration of assets value. So and survival of the business was really difficult when it will take time, because business have to suffer, because there are also a fixed expenses are also there, variable expenses are also there, but fixed expenses company have to bear. If it will take very much time, means for example, if manufacturing company is there, if we are not using machines, plant and machineries and machinery we are not using, so that what will happen? One side, the value of the assets will means there will be a deterioration of the valuation of assets, and also maybe plant and machinery will not be useful due to so many reasons, whether due to obsolescence, due to old machinery, due to change in demand, due to change in economic policy. So there may be so many reasons. So then when you will sold that plant and machinery, and if you want to buy new machinery, that will be very expensive for you, because if that machinery is not working condition, so then the value of that assets will not be, you will not be able to get. And another side, if you will buy new machinery, that will be costly. So due to all those things, survival or revival of the business will be really very difficult earlier. So that's why IBC code came into the picture. the main objective is timely resolution and maximization of the value of the assets. Okay. And also objective is to survive the business, not to close the business. The IBC code's intention is always there to survive the business. And we already discussed earlier objective to recovery of governments as statute dues was the first priority. Okay, that's why again survival and revival of the business was really difficult, because when you are facing challenge and your business is in the stake, okay, so then government is recovering their statute dues, so because your financial condition will be also means go down, so then survival and revival of the business chances will again means less or down. Okay, so that was the main issue and problem. And earlier also there was a, in this situation the control was given to the debtors. So they were means not very much interested to revive the business. Okay, the objective was to recovery. After IBC code, now the control is given in the creditors, and creditors we have already discussed financial creditor and operational creditor, because financial creditor have the special knowledge, special skill, because they are investing money. They can help to survive, revive the business. They can take the commercial wisdom decision. But they are taking commercial decision, but they will have to also take care all the other stakeholders. It should not happen. It should not. It should not happen, and it can't happen. They will not take the decision only in the interest of the financial sector. They will have to means that their decision will be fair and for all the stakeholders, because already clearly mentioned, when if survival of business is there, so then what will happen? Every stakeholder will get their dues. Okay, but if survival of business not there, if we are to recover the business and we are to distribute the sale proceeding after recovery, after sale of the assets, so then the priority is already mentioned as per section 53 as per waterfall mechanism. So means due to this clarity, if proceedings are distributing, so then it means there is a fairness, okay, for all the stakeholders. Okay, now shift from debtor in position to creditors in control. In the court's interpretation, underscored the shift in by the IBC from the traditional regime protecting debtors to a creditors driven resolution process where financial discipline is enforced through credit control. Okay, decision by the court. The Supreme Court dismissed the appeal filed by the Innovative Industries Limited and upheld the order of the NCLT or NCLAT, which had admitted the application filed by the ICICI Bank under Section 7. The court held that the protection under the MRU Code Act could not bar insolvency proceedings initiated under the IBC. It directed that the corporate insolvency resolution process be initiated against Innovative Industries Limited and the interim resolution professional be appointed as per the provision of the court. Okay. The conclusion. The Innovative Industries judgment is a landmark decision that laid down the foundation for the implementation of the Insolvency and Bankruptcy Code in India. It clarified that the legislation, intent, scope, and procedural framework of Section 7 applications and firmly established the supremacy of the IBC over other laws. The ruling has enduring significance for insolvency jurisprudence. It defined that the parameters of default determination, limited the discussion of the NCLT and reinforce the principle that insolvency proceedings are to be initiated on an objective and mechanical assessment of default, not on a subjective consideration or state intervention. Okay, means if default is there, so then NCLT or adjudicating authority have a limited authority. They will not allow, as per IBC code, adjudicating authority cannot take decision of the subjective consideration or any state intervention or as per any other law in case of inconsistent with the IBC code. Adjudicating authority will admit the application. So in this case, very clearly mentioned, in case of inconsistency with any other law, IBC code will override and application will be accepted under the section 7. In broader context of the insolvency practice, just a minute. In broader context of insolvency practice, the decision promoters value maximization, certainty, and the predictability. It ensures that resolution commences at the earlier stage of financial distress, enabling preservation of enterprise value and enhancing creditors' confidence in India's insolvency framework. The judgment thus serves as the cornerstone of IBC jurisprudence, giving how subsequent cases from Mobilex innovations to Vidarbha Industries Power have developed the contours of insolvency law under the code. Okay, now, so that was the leading judgment case between Innovative Industries Limited versus ICICI Bank. Okay, now we will discuss another leading judgment case between Swiss Ribbons versus Union of India. Okay. Okay. So this case was between Swiss Ribbons Private Limited versus Union of India and others. Okay, so date of judgment was 25th January 2019. A landmark Supreme Court case, Swiss Ribbons Private Limited versus Union of India, a cornerstone judgment under the IBC that constitutionally validated the code and shared the interpretation of section 7 and 9 applications. Okay, now refer just a 1 minute. The Swiss Ribbon case was a public interest litigation challenging the constitutional validity of various provisions of IBC code. The petitioner were promoters and shareholders of company facing insolvency proceedings under the code. They contended that several provisions of the IBC violated Article 14, 91G and 21 of the Constitution of India. The principal grievances raised were discrimination between financial and operational creditor under section 7(9) of the IBC, alleging that financial creditor were given preferential treatment in initiating insolvency proceeding and in participating voting in the committee of creditors. Okay, means in this case, the proceeding of insolvency prevention was challenged. As said, the provision is violating Article 14, 19, and 21 of the Constitution of India. So the main grievances were there is a discrimination between financial creditor and operational creditor, because financial creditors are covered under section 7 and operational creditors are covered under section 9, and only financial creditors can be the part of the committee of creditors. And also there was the issue, lack of opportunity for promoters and management of the corporate debtors to participate once CRP is initiated. Okay, because shift to control, catering control regime is there. So means, as we know, only financial creditors can be the part of the COC. So then corporate debtors, management, promoters, when CRP initiated, they also have the lack of opportunity for promoters and management, alleged violation of principle of natural justice in the process of admission and resolution, challenge to the power of the resolution professional and the constitutionality of section 29A, which barred defaulting promoters from bidding from their own companies. The Union of India defended the code, stating that the differential between financial and operational character was based on the intelligibility differentia and had a rational nexus with the object of the legislation, which was the value maximization and time-bound resolution. Okay, now what was the issue came before the court? Whether the distinction between financial debt character and operational character under section 7 and 9 of the IBC is discriminatory and is really violates Article 14 of the Constitution. Whether the code violates fundamental rights under section 14, 19 and 21 of the Constitution. That these were the issues before the court. Whether the power and procedures under the code include those of adjudicating authority, resolution professional and the COC are consistent with the principle of natural justice. Okay, so that was the third point. Whether the power under section 29A against defaulting promoters participating in the resolution process is arbitrary or unconstitutional. Okay, so these were the issues before the court. Okay, on the basis of applications submitted, case between Swiss Ribbons and Union of India. Now, gist of the verdict, Supreme Court upheld the constitutional validity of the IBC in its entirely and dismissed all challenges. Okay, means they have dismissed all the challenges. The judgment, authored by Justice R.F. Nariman, became one of the most significant pronouncements in insolvency law. Number one, valid classification between financial and operational, because question was asked, there is a difference between financial and discrimination between financial and operational character. So in this this point, Supreme Court given the judgment, there is a valid classification of financial character and operational character. The court held that the differentiation between financial and operational character is neither arbitrary or not discriminatory. Financial characters are usually banks and financial institutions who lend money based on the detailed credit appraisal, have continuous monitoring mechanism, and are better equipped to assess the viability and feasibility of a resolution plan. Because see, financial characters are usually bank and financial, operational characters may be supplier and lender. Okay, now operational characters on the other hand supply goods and services and may not possess similar financial expertise or ability to restructure the debt. Hence, treating these two classes differently under section 7 and 9 serves a legitimate and rational purpose. Okay, so that was a valid point. This question asks that there should not be any discrimination between financial character and operational character, but IBC code classified operational and financial character. Practically, if we see, the financial character can take the decision because these are the banks and financial institutions. They can also means they are better equipped. Okay, and operational character on the other hand, they are supplying goods and material and providing services, and also means employees and government dues and statutory authorities are also there. Okay, but financial writer have the expertise, and they are the better decision can be taken by the financial writer as compared to the operational writer, because financial writer can also restructure the debt. Okay, because they are to recover the amount, so they can also restructure the debt. They can also arrange further debt, because they will also interested, very much interested as per the objective to revive the business. So means that differentiation is not discriminatory, no, neither arbitrary. Okay, and also section 7 and 9 serves a legitimate and rational purpose. So that was a valid point given by the Honorable Supreme Court as per the IBC code. With there is the differentiation is legitimate and rational purpose. The purpose behind is to achieve the objective under the IBC code 2016, because the objective is this: to survive the business and maximization value of the assets. That can be done better by the financial characters, because they are the expert and they have the ability. They are expert and they can restructure the debt. So that's why it's valid, it's legitimate, and it's rational. That is fair. Okay. Now another issue was there: role of financial character in COC. Okay, because thus, as we have already discussed, because only financial characters may or will be the part of the COC. The reason behind is this: they are well expert and they are good to take commercial wisdom decisions. So that's why court upheld the court held that the committee of creditors comprising financial creditors plays a central role, because it's the best positioned to decide on the feasibility and the viability of the resolution plan. Operational creditors are protected through minimum guaranteed payment under section 32B and the monitoring powers of the adjudicating authority NCLT and GRADE. Okay. Because financial creditor plays a central role, because they are best positioned. They can take the viability decision. They can can take the decision about the resolution plan. So they are expert, because they are in the finance domain, so they can take the better decision as per IBC code. That's why financial characters are included in the committee of characters. Okay, but although operational characters are also treated, and their claim will be as per the section 53 waterfall mechanism. So there is no unfairness with operational character, because all the financial commercial decisions if taken by the committee of characters, so then so these decisions will be fair and applicable and in the interest of all the stakeholders. So then COC members cannot take decision only in the interest of the only financial character. They are to take the decision in the interest of the business, in the interest of the all the stakeholders. If they will take, they will do, or if they will take the like this, to then adjudicating authority is also there. So adjudicating authority will not allow to do these unethical activities, because adjudicating authority, NCLT and CRADE also monitor, because all these CRP process and liquidation process is done under the supervision, under the monitoring of the adjudicating authority. Okay, so that's why the role of financial character in COC is also as per legitimate and as per the objectives of the IBC code. Okay, so that is also fair. Okay, now in this case also it was discussed nature of proceeding under section 7 and 9. Section 7 applications filed by financial writer and section 9 applications filed by the operational writer are distinct in purpose and nature. Okay, so now Supreme Court, as per Supreme Court judgment, under Section 7, the NCLT must admit the application once a default is established. The creditor's motive or state of mind is irrelevant. Okay. Under Section 9, adjudicating authority must additionally examine the existence of pre-existing dispute before admitting the application. The distinction the court held is rational and constitutionally valid. Okay. So means nature of proceeding, Section 9 and 7. Process, acceptability, okay, as per IBC code. Applications for Section 7 and Section 9 as per IBC code. So then adjudicating authority will accept the application. That is also mentioned in this judgment. It's also very much evident from the IBC code itself also. Means if there is a pre-existing dispute, the adjudicating authority will not means accept the application. So that is already very clearly mentioned in the IBC code 2016 itself. Now, no violation of article. The main contention for this application against means in the Honorable Supreme Court, the plea was that these means Section 7 and IBC code, and these section and provisions are violating the fundamental rights which are given by the Constitution of India under as per Articles 14 and 19. The court emphasized that IBC represent a paradigm shift from debtor in possession to creditor in control, which was necessary to restore credit discipline and the investors' confidence in India. The code was designed to revive viable companies rather than to liquidate them, thereby promoting the public interest in economic growth and financial stability. So that is also fair because now paradigm has shift. Earlier, debtor in position, the main objective to recover from the business as per those acts. Main intention was not to revive the business, main intention was to recovery from the business. Now paradigm shift. Now, as per IBC code, control is given in the hand of the creditor in control. So then, as per objective, under the IBC code is to revive the business in the public interest, in economic growth and financial stability. Now, there another issue was on regarding Section 29A, bars on promoters. The court upheld the validity of Section 29A because Section 29 says if there is a default at the end of the promoters. Okay, so then see here, the court upheld the validity of Section 29, holding that persons who had contributed to the company's default should not be allowed to regain control during the resolution process. These provisions, the court noted, was aimed at ensuring integrity and transparency in the resolution mechanism. Because when there was an issue and there was a default at the end of the management, if the same management and person will come in this process and take decision, okay, if they will again take the decision, so then business will not be able to will be difficult to survive the business, because if they will control during the resolution process, so then it will not fair. If as per provision is to ensure the integrity and transparency in the resolution mechanism, so then the power to take the decision and control is given to the financial creditors, and financial creditors who are the part of the COC members as per the code. Top 18 financial creditors are taken in the COC. Okay, so that's why Section 29 bars on the promoters is means justified, because when they have already done the defaulted, then again they will get the control. That will not fair and not ensure integrity and transparency in the resolution process. So that's why, as per the objective of IBC code, the control will be in the hand of carried in control as per the IBC code 2016 to ensure the integrity and transparency. Okay. The another issue was timeliness and value maximization. The Supreme Court reiterated that the IBC course objective is time-bound resolution and maximization of the value of the assets. As it's already clearly evident and mentioned in the IBC code, the main core objective is time-bound resolution and maximization of value of assets. Delays in insolvency proceedings erode enterprise value, defeating the purpose of the code. Hence, adherence to the statutory timelines section 7, 9 and 12 is critical, because in earlier act what was happening, it was a time taking that due to this there is a deterioration in the value of the asset. So then revival of the business was really difficult. Okay, the percentage of revival of the business is very low. Okay, so that's why after the IBC code, it's a time-bound process. CRP resolution process is to be completed within 180 days, and liquidation process is to be completed in 365 days in 1 year. So that is very critical and important. If revival of the business is not practically possible, then company will go to liquidation. But in this process not take very much time as compared to the earlier act was taking very much time. So that is the difference. Now the timeliness value maximization is Supreme Court, Honorable Supreme Court also again reiterated that the IBC objective is time-bound resolution and maximization of value of the asset. Okay, so that is very important and critical. That is the main thing for IBC code. Time-bound with maximization value of the assets during CRP. Okay. Otherwise, in case of liquidation, time-bound resolution, time-bound will be there. In that case, the objective will be to close out the business and sale of the assets, and proceeding of the sales is to be distributed as per under section 53 waterfall mechanism. Now, another was principle of natural justice. Is this code or these sections are principally of natural justice? The court clarified that adequate safeguards exist in the code. The corporate debtor is given notice before admission of an application, has the opportunity to be heard, and can appeal decision before the and Supreme Court. Means natural justice is there because corporate debtor is also given notice before admission of an application, and they also, if they are not satisfied with the adjudicating authority, means what with the procedural NCLT decision, so then they can approach to the advocate and then can approach to the Supreme Court as per the IBC code 2016. So means there is a natural justice also there, because it's not happening only one authority is dealing and handling and managing. Okay, and decisions given by the NCLT is the final, and means party cannot approach to further means authorities. This thing is not happening. So means it clearly defines first case will be admitted by the NCLT if any party is not means satisfied with the decision of the NCLT, so that they can further apply it and approach to the NCLT. If they are also not satisfied with the decision of NCLT, then they can also approach the Supreme Court. Now, just in reference to valuation principles, the Swiss ribbons judgment is crucial for the jurisprudence of value of maximization and economic rationality in insolvency proceedings. The court recognized that The primary objective of IBC is resolution, not liquidation. Okay, that is the primary objective. Value maximization benefits all stakeholders, creditors, employees, and the economy as a whole. Okay, because if value maximization is there, so then the resolution applicant will submit the resolution plan with COC. So if COC will means approve the resolution plan, which is which have the maximization value of the company or asset. Okay, so now it focus more on the maximization of valuation of the company or asset for which COC members take decision under the IBC code 2016. Financial creditor who are better equipped to evaluate viability and feasibility play a key role in determining the value of the debtor's assets through COC. The court affirmed the valuation under IBC is not a merely a financial exercise, but a strategic assessment to preserve going concern value. Means, as we have already discussed, when any company is in the process of CRP, so then the approach is going concern approach. Okay, when CRP is not feasible, then company go into liquidation. So then the approach will be not the going concern approach. Then approach will be to close the business, to sell the business. Okay, to sell the business. Then the approaches are different during CRP and liquidation. The judgment thus cemented that the valuation, preservation, and revival philosophy of the code, aligning it with global insolvency best practices. Okay. Other principle, resolution before liquidation, the code prevails revival and restructuring of distressed companies over liquidation, as liquidation results in loss of assets value and employment. Economic legislation and judicial restraint. The court observed that economic legislation like the IBC are complex and experimental, and judicial interference should be minimal unless the law is manifestly arbitrary. Protection of operational creditor. Although the operational creditor don't have voting right, okay, their interests are safeguarded by statutory minimum payments and the obligation of equitable treatment under approved resolution plan. As we know, if operational creditor have debt claim more than 10% of the 10% claim of the total debt, then they can participate the COC meeting, but they don't have the voting right. Voting right have only with the COC members, and COC members, financial creditors, when they take decision, when they take an important decision, so then voting percentage must be more than 66%. When they are taking normal decision, then the voting percentage must be minimum 51%. Dynamic nature of the court. The court acknowledged that the IBC is an evolving legislation capable of being refined through amendments as practical experience grows. The observation paved the way of future amendments such as 2019, 2020, 2021. Okay, we will discuss this thing. Means the court acknowledged that the IBC is evolving legislation capable of being refined through amendments as a practical experience grows. Because see, as of now, the amendment is being done by the in the IBC code. For example, if they, as we have already discussed, some of the matters we don't have a specific means rule and regulation, specific sections are there. For example, cross-border insolvency resolution related provision we don't have. Okay, and group insolvency resolution process we don't have. So when they will come, so then IBC amendment in the IBC will be done, and these sectional provisions will include in the IBC code 2016. Previously years also it is included some of the provisions related to home buyers. Okay. Now, decision by the court, the Supreme Court dismissed the petition and upheld the constitutional validity of the IBC. In its entirety, it confirmed the legitimacy of the distinction between financial and the operational writer. The decision-making power of the COC, the procedural mechanism under section 7, 9 and 10, the disqualification provision under section 29A. The court concluded that the IBC serves the public interest, ensures credit discipline, and promotes the economic health of the nation. The conclusion, the civis Deepan's judgment is a milestone in the evolution of the India's insolvency jurisprudence. It forfeited the constitutional foundation of the IBC, upheld its creditor-centric design, and reinforced the legislative objective of value maximization, revival, and financial discipline. For insolvency professional and creditors, this case is significant for the following reason. Okay, but here I will discuss key in this case now. In shortcut, if I will say, the IBC court was challenged. Okay, means giving the reference that IBC code is against the article of 14, 20, 14, 19, 21. So means IBC code was challenged. In this judgment given by Supreme Court, decision and confirmed all the provision, all the sections are relevant as per the IBC code. The objective is okay, financial and operational criteria okay, COC is okay, disqualification provision of 29 okay, means all the rule and regulation sectional provisions are consistent and are with the objective of the IBC code, and IBC code is means constitutionally means valid. Now, key jurisprudence. Okay, now for insolvency professional and creditors, this case is significant for the following reasons. It validated that the differential treatment of section 7 and 9, establishing that financial and operational creditors are inherently distinct. Okay, that is also valid. It reaffirmed the objective and time-bound nature of insolvency proceedings with maximization value of the assets. It also provides judicial recognition to value, preservation, and economic rationality as guiding principles of insolvency resolution. In essence, Swiss Ribbons versus Union of India cemented the IBC as a constitutionality sound, reformative, and credit-driven legislation that balance the twin goals of the resolution, means timely resolution and value maximization, a decision that continue to shape all subsequent interpretation of the code. Okay, so that was a very important in this case when IBC code is being challenged. So then Supreme Court is giving judgment, all these rules and regulations and differential treatment, the section 7 and 9 for operational criteria, financial criteria is legitimate. Okay, so means that is all these rule and regulations are as per the consistent and as per the objective of the IBC code. Okay, now we will cover the another case in short. That case was between Vidarbha Industries versus Axis Bank. The Supreme Court judgment in Vidarbha versus Axis Bank Limited marked a significant departure from previous interpretation, section 7(5)(a) of the IBC code. The court held that word may in section 7(5)(a) confers discretion upon the NCLT to admit an application for initiating the CRP even when the existence of debt and default are established. Okay, so that was the main issue. Brief facts. Vidarbha Industry Bank is a power generating company. Axis Bank filed application under section 7. Okay. To be stayed as an appeal, Maharashtra Electricity Regulatory Commission against an order passed by the appellate tribunal, which determined that sum of 1730 were due to the corporate debtor was pending before the Supreme Court. Vidarbha Industries argued that the implementation of the APTEL order would enable it to clear all outstanding liabilities. The NCLT and CLAT dismissed these stay applications, leading to the appeal before the Supreme Court. Okay, now what was the issue? The primary issue before the Supreme Court was whether the use of the word may in section 7(5)(a) of the IBC confers discretion upon the NCLT to admit an application for initiating CRP even when the existing debt or default are established. Okay, the gist of the verdict. Section 7(5)(a) is directory and not mandatory. This grants NCLT discretion to admit or reject an application for initiating CRP even when the twins condition of existence of debt and defaults are satisfied. The court emphasized that NCLT should consider the overall financial health and viability of the corporate debtor before admitting the application, ensuring that solvent companies temporarily defaulting in repayment are not unduly penalized. The gist in reference of valuation principle, the judgment underscored the importance of assessing the financial health and viability of the corporate debtor before initiating CRP. This approach aligns with the valuation principle that consider not only the existence of debt, also the debtor's ability to repay and the potential for revival. By allowing NCLT to exercise discretion, the court ensure that the resolution process focus on value acquisition and the revival of the viable business. Other principles: discretionary power of NCLT, consideration of financial health, judicial precedents. So these were the other principles was there. Now, what was the decision given in this judgment? The Supreme Court dismissed the appeal, upholding the decisions by the NCLT and CLAT. The court emphasized that the NCLT has discretion to admit or reject an application under section 5(a), considering the overall financial health and viability of the corporate debtor. Conclusion: the Vidarbha Industries case represents a significant shift in the interpretation of the section 7(5)(a) of the IBC by recognizing the discretionary power of the NCLT. The court ensures that the resolution process is not merely mechanical but considers the broader financial context of the corporate debtor. This approach aims to balance the interest of creditors with the need to revive viable business, aligning with the objective of the IBC to promote value maximization and economic revival. Okay. So these were the cases. Another case we can also, in shortcut, we can discuss. Another case is on the section 9. Case between Mobilaxing Innovation versus Kurusa Software. Mobile Box was a technological company, have contractual agreement with Kurusa Software Private Limited. Okay. The corporate debtor allied failed to pay Mobilex for service rendered amounting to 42.25. Okay. The operational creditor filed application under section 7 under section 9. Okay. The corporate debtor opposed the application, contending that a pre-existing dispute existed between the parties regarding the quality of the software and the terms of payment. The corporate debtor argued that Section 9 proceedings could not be initiated because the debt was disputed. The NCLT admit the application under Section 9, and the NCLT upheld the decision the corporate debtor then approached to the Supreme Court. The key legal question before the Supreme Court, whether an application under Section 9 IBC can be admitted, whether there is a bona fide dispute regarding the debt between the operational debtor and corporate debtor. Specifically, the court had to examine the scope of the NCLT's power to reject Section 9 in the presence of the pre-existing dispute. Okay. The gist of the verdict was the Supreme Court held that existence of a bona fide dispute, if a pre-existing dispute exists or the debt is contested on legitimated ground, the operational creditor cannot invoke Section 9. The court insists that a Section 9 application should be admitted only when the debt is undisputed. We have already discussed, if pre-existing dispute is there, then adjudicating authority cannot accept the application as per the IBC code 2016. And another question was their threshold for rejection. The Supreme Court clarified that NCLT should not adjudicate the merits of the dispute. Instead, it should determine whether the dispute is genuine and pre-existing. If there is evidence that the debt is genuinely disputed, the NCLT must reject the Section 9 application. Operational and financial creditor, this we have already discussed. Section 9, the risk of dispute over goods and services are require careful examination of whether the disputes are existed before the notice under Section 8(1). Means, for example, if supplier is submitting the application under Section 9 and as per Section 8 need to issue demand notice at least before 10 days. If that dispute was before then issuing demand notice, so then it will be in the purview of the existing dispute. If after issuing the demand notice, okay, if any issue is raised, so that will not cover under the pre-existing dispute. That will not be a genuine dispute or pre-existing dispute in the in the definition of the pre-existing dispute. Okay. Now, notice requirement, the court insists that the operational creditor must issue notice under Section 8(1) before filing a Section 9, and also along with at least 10 days before that the demand notice must be issued at least 10 days before. If the corporate debtor raise a bona fide dispute in response, the application cannot proceed. Okay, now other principles defining of pre-existing disputes, operational creditors burden. Okay, means operational creditors bear the burden of proving the debt is undisputed. Okay, so that is need to prove by the operational creditor. Now, limitation on NCLT is required. NCLT cannot adjudicate the technical merits of the dispute if it only needs to assess the existence and genuineness of the dispute. Consistency with the legislative intent, decision by court. The Supreme Court dismissed Section 9 application filed by Mobiles, stating that a bona fide dispute existed. The court held that the NCLT must reject applications where a pre-existing dispute is established, even if the debt is not fully settled. Okay, means fully, if debt is not fully settled, and although a pre-existing dispute is also, then adjudicating authority is not allowed to accept the application. Okay, so that was the conclusion. The principle of pre-existing dispute. Section 9 cannot be used to enforce disputed operational debts. Okay, so that was the conclusion. If pre-existing dispute is there, so then adjudicating authority cannot accept the application. Okay. So these were the landing and important judgments were there. If you have any query and question, you can ask. Otherwise, we can conclude the session.
Good evening, sir. Sir, one query. Are you able to hear me, sir?
Yes, yes.
Yeah. So one query. I don't know whether I missed out during the day. Sir, one point, like, see, between IBC and the Companies Act, IBC provides that once the CD is submitted to CARP or liquidation, the directors get suspended.
Mhm.
Is there a similar provision like that in the Companies Act, sir? I have not come across whether the directors get suspended in Companies Act also.
When we are talking about the IBC code, when if IBC code will, as we already discussed, the IBC code will override the Companies Act.
Yes, sir. Yes, sir.
So then we need to follow the IBC code.
No, sir. My reference is not to that, sir. I understand. My reference is that suppose a winding up order has been passed in under Companies Act by NCLT, then under what provision is there a provision by which the directors get suspended? Similar to IBC, is it like that? Any idea?
As per Companies Act, I will have to check as per Companies Act, because
Okay.
I'm expert in IBC, but I
Okay.
don't have any clarity on that part.
Okay, sir. No problems. Okay, thank you.
Okay. Okay, we can conclude the session. Thanks.
Thank you, sir.
So shall we conclude?
Yes, we can conclude.
Okay, thank you very much, sir, for such a nice and good session. Sir, you are requested to share a presentation with us.
Okay, sure.